This is the regularly scheduled meeting of the Sunshine Ordinance Task Force, called to order at 4:06 on Wednesday, August 6th, 2014.
Item number 1, on the call of the roll. Member Rummold.
Present.
Rummold present. Member Winston.
Present.
Winston present. Member Wolf.
Present.
Wolf present. Member Pilpel. I was informed by Member Pilpel that he is ill and will not be able to attend today. Member Hepner.
Present.
Hepner present. Member David.
Present.
David present. Member Fisher. I was informed by Member Fisher that she will be here today. She is running slightly late. Member Oka.
Present.
Oka present. Vice Chair Highland. Highland present. Chair Washburn.
Present.
Washburn present. I would like to inform you that item number 9, file number 14053, complaint filed by James Dixon against the SFMTA. The complainant has withdrawn that complaint. And item number 2, 3, 4, and 5 by Anonymous against the Planning Department. I do have a request from the complainant to continue this item. I believe it is due to a medical issue,
Okay.
but I do not know for sure.
All right. So what this means is we have quite a shorter agenda than we had thought, which will give us ample time to discuss our response to the civil grand jury report, for one thing. We ought to be able to be fresh when we discuss it this time, unlike last time. I want to make sure that we time the items so that general public comment does not come until 5 o'clock, because members of the public expect that that's when it's going to be. So even though that's really, I guess, the next thing on the agenda after the anonymous complaints, which have been continued. I would like to, if there's no objection, wait until 5 for that. Member David?
I just have a question about the anonymous, the complaints. I just was a little unclear. Was it Anonymous who asked for the extension?
Yes, it was Anonymous. Her wording in her email was unclear. She asked that we cancel the meeting, but her voice message inferred that she wanted to continue. And I have not received any clarification at this time, so I believe her request is to continue the matters.
And so I'm just wondering, is this something that we want to, at least as a task force, discuss whether we want to continue it, or should we just do it without a discussion?
Yeah, I'm not sure the procedure here does this require a motion to continue, or?
It does require a motion
Okay.
to continue. Because this request came in at the late time,
I see,
it's
okay.
in the hands of the committee. However, I did inform the planning department of the request, and I don't believe they intend to attend the meeting today.
Okay. All right, so at this time, do I hear a motion to continue these items?
Motion to continue.
Is there a second?
Second.
All right. Members, is there any discussion before I open this up for public comment? She also sent, Anonymous sent an email to us through the office about this. I don't know if everybody got it. I got a copy of it.
That's only referred to the chair and the vice.
Okay, all right. Any discussion, Member David?
Yeah, my only comment is that, we obviously have such a huge backlog. And, for at the last minute for someone to ask for an extension, we're continuing the problem. I certainly, if the person is truly ill, right, we're going to offer an extension, but we're now at, I think there were 8 items on the 8 different issues to hear, and now we're hearing 1 or 2. Mm-hmm. And so that's my only concern about setting a precedent where at a last minute request for an extension, will be granted.
Member Wolf?
This is slightly off topic, but assuming that we do end up rescheduling this, I would like to know why it's because it seems like it's the same email that triggered more than one of these complaints, and I'd like to know why it's scheduled as separate hearings. Is it because Anonymous filed multiple complaints separately?
I did start off with them as one complaint. However, at the request of Anonymous, she stated that each email should be a separate complaint, so I complied with her request.
Great, thank you.
Other members? At this time, I'd like to hear public comment on the motion to continue these items to a later date.
Good afternoon, Thomas Piccarello. I would like the task force to share the reason for the continuance. The members of the public didn't have access, nor did you provide us with the email. But I would agree completely with Member David regarding Anonymous. She has caused innumerable delays on pending cases. I'm waiting 90 days, if not more, for you to hear my complaints. So I would strongly oppose this motion for continuance and request that you take her off calendar. It's nice that you'll be able to discuss the grand jury report, but it's not nice for the complainants who are waiting 90 days or more to have their complaints heard. So I oppose the motion for continuance. Thank you.
Thank you. Are there other comments from members of the public?
Richard Nee, respectfully, I suggest that you continue this matter to the call of the chair.
Peter Warfield, I support the motion. I believe you said there was a medical issue with respect to 2 through 5, and I appreciate the accommodation of the requester for separate hearings on complaints that go against separate departments. I also would note that I don't think there's any need to be apologetic about public comment. It, in general, has the appearance of a special order, and a special order says, under Robert's rules, that it will be taken at or after the hour mentioned once the item that is in progress is completed. And yes, the public does expect to have public comment at or after 5, not before. They make plans that way, and so I don't think there's any need to apologize about following ordinary parliamentary procedure and courtesy to the public. In any case, it is unfortunate. You need to think about what to do with respect to last-minute changes so that you don't get left, in a sense, holding the bag. But these things happen. If you have had any dealings in court, I think there are endless sorts of delays and things happening so that it's very hard to judge ahead of time in judicial procedures when things are going to happen or be settled. So I don't think you have anything to be ashamed of or embarrassed about. And I support the motion to continue this. Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I apologize for being late and missing the conversation on which this whole motion is predicated, but changes in the agenda should be minimized. Bottom line is there are too many games that are played with public records and public access to meetings where one or the other party will try to maneuver around getting a hearing and getting it done in an expeditious fashion. If there is a substantial or substantive reason for this person to delay 5 complaints at the time of the meeting, prior, this should have been something they were aware of well before the meeting was set to occur. And as much as I am always in the favor of the respondent and feel that they have a heavy load to bear anyway, I do feel that changing the agenda at the last minute is contrary to public policy. People who come here look at your agendas and they attend the meetings based on what the agendas say. And if they start to show up and the agenda isn't followed and they know they can't count on the agenda, after a while what you will get is people who just don't even bother to look, and worse, don't bother to participate. And again, this is something I rarely do, but I'm also on the side of the city and its need to maintain payroll and all the other things that are put in here. And basically, if somebody is showing up at the last minute saying, let's delay this, they have to really figure out that it is the other person's negative issues that they're going to have to deal with. Now, I would be just as willing to get up and say these things if it was the respondent asking at the last minute for a complaint. I think that when the agenda is set, all of the parties have an obligation, both morally and legally, to comply with the agenda, and if they can't, they need to let the task force know as soon as possible, which in most cases should be well before the actual meeting. That would give plenty of time for the other party to change arrangements or send somebody home rather than having them sit around City Hall collecting overtime and whatever else they need to pay them. So basically, if you really feel that this is an appropriate thing to change it, I'm not going to argue with you about it, but I think that going forward, this task force, as the body who really is responsible for ensuring that all city agencies and bodies follow the law, the Sunshine Ordinance, you should give precedent to the fact that the agenda was set, it was publicly announced 3 days ago or more, and it met the criteria and should not be changed at the last minute.
Thank you.
I support this motion to continue it to the call of the chair. That gives a way to put it off at an indeterminate amount sometime in the future. If there was a medical reason, Anonymous could have said it long before the last minute, and owing to the fact that there is a huge backlog and people are waiting, I would hope that in the future she doesn't do it again, because she has so many complaints in the queue.
Thank you. Is there any additional public comment? Okay, I just reread her email, and she doesn't say why she wants the continuance, but she let us know, I believe, on Monday. And the planning department was contacted, and so there was no one here from the planning department. So my assumption is that perhaps she's ill, and that was apparently what she could have sounded like that was the case in the voicemail. So that's my take on it. As far as continuing this to the call of the chair, I think that's a good way to proceed. Does our motion cover that, or do we need an amendment to the motion?
We can just state that this motion is to continue the matter to the call of the chair, and we can vote on it.
Okay, all right. So would you call the roll, please?
On the motion to continue the matters to the call of the chair, Member Rummold?
Aye.
Rummold, aye. Member Winston?
Aye.
Winston, aye. Member Wolf?
Aye.
Wolf, aye. Member Hepner?
Aye.
Hepner, aye. Member David?
No.
David, no. Member Oka?
No.
Oka, no. Vice Chair Hyland?
No.
Hyland, no. Chair Washburn?
Aye.
Washburn, aye. The motion passes by a vote of 5-3. This is a procedural motion, and it only needs a majority of the members present. Next on the agenda is item number 7, file number 14019. The Education Outreach and Training Committee has referred file number 14019 to the Sunshine Ordinance Task Force. Complaint filed by William Clark against Dennis Herrera, Jack Song, and Gabriel Zitrin, City Attorney's Office, for violating Sunshine Ordinance Section 67.29-7 for failure to maintain appropriate records in a business-like manner.
All right. I see that the parties are here. Well, I see the, okay. So I'd like first for members of the EOT to bring the rest of us up to speed on what happened, I guess it's your last meeting where this matter was heard. We have a lot of material in the packet, but you referred it back to the task force, so I'd like to hear your reasoning for that. Thank you.
So I believe myself and Member Oka were the two members tonight who were at the EOTC. Member Oka, you were present at this. Is that were there also? Oh, I'm sorry, Vice Chair Hyland. Do you want to? Oh, okay. I'm sorry. Chair Pilpel usually, or not Chair Pilpel, but the chair of the EOTC, Pilpel, usually gives the report. So I think I'll try to encapsulate, I'll try to condense what kind of the key issue was. So, and I would certainly invite the Clark brothers and the city attorney to give their version if they don't feel that I'm wrapping it up. If I'm wrapping it up correctly. But it basically came down to, if I'm remembering correctly, the following was that the city attorney was taking the stance that all work product, even when it comes to Sunshine and Brown Act information, is covered by client attorney privilege. And that was the stance that the city attorney was taking, and that we as a task force said that a plain reading of the Sunshine Ordinance does not, kind of disagrees with that, and there was some reference to the case that's going on in San Jose, and so that's why we referred it back to the full task force. There was, I think, a feeling of that this question of what is disclosable as far as between the city attorneys and department heads and the city attorneys and just board of supervisors, any government, any city government really gets at the heart of a lot of the issues that we deal with. And so we felt that this was important to bring it back and to discuss as a full task force that, once again, a common reading of the Sunshine Ordinance seems to belay the city attorney's argument. But the city attorney also pointed out that the San Jose courts are kind of taking this up as an issue. Was that, Vice Chair Hyland, Member Oka, was that roughly it?
I guess I'm
Yeah.
Oh, good.
I think it's a San Francisco. It's a court of appeal, but here in San Francisco.
Oh, I apologize. I thought it was San Jose. I didn't realize it was a Grossman issue. Sorry.
Text issue.
Okay.
So yeah, that's. I mean, not having been at the hearing, that case sounds applicable to what you just described.
Microphone, please.
Sorry.
Okay, I guess I'm a bit confused. I was reviewing the material in our packet and looking back at the order of determination dated May 27th. On this,
sorry, Chair. Whoever has that cell phone, please silence it. It's gone off 4 times now. Thank you.
And yeah, I'm familiar with the issue you're discussing, and it's pertinent here. But we were citing section 67.29(7) for failure to maintain appropriate records in a businesslike manner. So is that correct?
Yeah, so we were saying that there's this kind of catch-22 with this situation, right? So, and yes, that was the actual complaint.
Okay.
But underneath the heart of it was the following, right? That if the city attorney is supposed to disclose everything when it comes to sunshine, right, then there needs to be appropriate record keeping, right? And so if that is the determination, then there wasn't appropriate record keeping, right? But simultaneously, the city attorney made two arguments that no, they don't have to create any records, right, because of the sunshine, and they also think that there's a work product. So it was kind of, at the heart underlying it is this question of what is disclosable or not, right? If it is disclosable and they weren't disclosing it, then there was a lack of keeping professional records. So that was the case. Does that make sense, what I'm saying? Maybe someone can, maybe Vice Chair.
Yes, in a way, but
And
Member Highland.
through the chair, I think if you turn to page 56 of your packets, there is a table there showing the entries where a staff member, Aideen Vera, references discussions with the Street Artists Program. But as you can see, that's it. There's really no information there. It doesn't say what it was about. There's no relevant data there, and that's part of the 29.7 issue of keeping adequate records. That was part of it. But as Member David said, the underlying issue is, the whole client privilege issue that's underlying this. But yeah.
Okay. I guess I was looking at this more narrowly, that looking at these records of the time spent and the amount charged, there's so little information here. Anything related to sunshine and the public records is just called that. There's nothing else here. So my question was, couldn't more be said?
So basically, in a nutshell, the full task force found a violation. It was referred to EOTC. Nothing was changed on the part of the city attorney's office, and that's why we're back here.
Okay.
And that's basically where we're at.
All right. So at this time, I don't want to re-adjudicate the case. So I'm wondering the best way to proceed here.
If I can make a short statement.
Well, maybe that would be appropriate. So if you would identify yourself.
I'm William Clark. Okay. Basically, I agree with everything you said, and that the bottom line was that even if the city attorney had these records, he would refuse to do it until this court, and he was claiming the court case was in effect, and I was saying that until the court case made a ruling in his favor, that under the law, I'm entitled to this information at the present time. And in the packet, I presented to the committee from page, I think it's 49 to about 56, numerous emails that were sent back and forth from the Arts Commission to the city attorney's office in 2009 and 10, in which they discussed many Sunshine Ordinance requests. And in this particular case, the city attorney is claiming that there is no communication, there are no records, and I presented that as evidence to show that as recent as 2010, the city attorney's office has been communicating to departments through emails about this, and now all of a sudden we have no emails at all. And I requested to find out from the city attorney when that policy was changed from communicating back and forth via email and no emails at all, or records of them at all. And I also presented from one of my previous cases, 13025, I believe it's on page 36, an email from Mr. Lazar in which he states that on April 8th he communicated with the city attorney's office And then on April 16th, he again communicated with the city attorney's office about this matter. And I had looked at the sheet, the time billing sheet, which if you look to, it's going to be page 6 of the time billing sheets. I'm not sure exactly what number that is. It's probably page, if you give me a second here. I see it, but I don't know which number it is.
60, I think.
It's on page 6. But for the dates between April 8th and April 16th, there is no accounting at all of that consultation with the city attorney's office. And I'm very suspicious, because if he did consult with the city attorney's office, that should be recorded on this time billing sheet, and it's not. And so I requested the city attorney's office to explain why there was this consultation and it doesn't show up on the time billing sheet, and also to explain about the fact that they communicate to the Arts Commission through emails, and now all of a sudden they don't do any. And then there was one other minor little thing I wanted to point out to you, was that you actually, in case number 11002 in your log, which was 1/11/2011, you found the city attorney's office in violation of section 6721I, which is acting as the city attorney for the department, and you found him guilty and in violation at that time, and that was a very similar thing. And what I'm saying is that I believe that the city attorney's office is continuing to act as an attorney to help the Arts Commission not release this information, and that because you found him guilty of that in the past, that he doesn't want any more emails to come forward that would indicate that he's been advising the Arts Commission on how not to release public information, because everybody agrees that these public record requests, the information on the billing sheet is inappropriate. The Arts Commission has refused in another case to give me that information on the basis that the city attorney told him that he didn't have to release that information. So that was a recent case. And at this last hearing, the city attorney made a comment about how, if the department wants to release this information, they can. And I had to remind the committee that the city attorney advised the Arts Commission not to release that information, claiming it was attorney-client privilege. So all I can say is that under the law as it is now, I'm entitled to this information. I believe emails are being withheld from me indicating what was communicated, and I would like you to do something with this as a willful misconduct.
Thank you. At this time, I'd like to hear from the City Attorney's Office. Mr. Zitrin.
This is the case.
Well, I don't really know how many times we have to go over this. That is not a violation. Mr. Clark seems to think that the Arts Commission, if the Arts Commission exercises that discretion, it is a legal principle. When you have an attorney and you have a client, the attorney cannot disclose what has occurred between the attorney and the client, in this case the Arts Commission, has the option. And the attorney is perfectly entitled to advise the client, you have the option of either disclosing our discussions to a third party or not. Mr. Clark may not be happy that is the law, but it is. And you can't change that by finding that in violation. That's what the attorney-client privilege is. Also, one thing I can say is that the appellate court has now ruled on the Grossman versus Ethics Commission case in favor of the Ethics Commission. They adopted more or less all of the city attorney's arguments, saying that the legislation cannot legislate, the Sunshine Ordinance cannot legislate the attorney-client privilege, cannot legislate any defect in the attorney-client privilege, that it remains intact. So, I'm sorry, I'm not hearing any variance in his argument. He says they can't simply withhold on the advice of their lawyer the subject of those consultations. Yes, they can. That's what the attorney-client privilege is. If we move this from here to a downtown law firm, and Mr. Clark sees a client walk out of a consultation with an attorney, and he walks up to the attorney and says, hey, what were you guys talking about? The attorney cannot answer. It's not a matter of I elect not to answer. It's, look, I'd love to tell you, but I can't because I'm their attorney and I just had this consultation in confidence with them. Now, Mr. Clark, excuse me, Mr. Clark is free to go to the client and say, hey, what did you just talk about with your attorney? And the client has the option to say, oh, well, we talked about this, or to say, I decline to answer that. And the attorney will advise, any decent attorney will advise the client of that and say, yes, when you get out of this room, you can either tell people what transpired between us, or you cannot tell people what transpired between us. Mr. Clark may not be happy that that is what attorneys and clients are entitled to do, but that is what it is. And to say that because of that you must find a violation of the Sunshine Ordinance is preposterous. Now, there are issues, we've been looking at these billing records for a while, and this reflects a little bit of what I'm talking about, because these billing records are really kept as they are not subject to the Sunshine Ordinance with respect to their content, only with respect to the amount of time and money spent. Anything further is kept for the benefit of the client, in this case the Arts Commission, but also other policy bodies and city departments, because the client needs to have an accounting of what they're paying for. Similarly, when an attorney, my hypothetical downtown attorney, he's charging his client or her client for services rendered, yeah, you need to keep records sufficient so that the client can say, oh, okay, that's what I'm being charged for. We do keep such records. And if those records are to be disclosed by the client to somebody like Mr. Clark, they can disclose whatever of those records that they like as far as the content, and they can withhold those that they like. And again, Mr. Clark might not like the fact that that is true, but it is true. And that's the way it is. You can say they're advising the Arts Commission that they don't have to release those emails. Yes, we are. We're their attorney. We advise them as to what their legal rights are, and then, as the client, they, the Arts Commission, have the option either to waive the attorney-client privilege with respect to a third party or not to. Mr. Clark may not like that that is true, but it is true. There is no deficiency in record keeping here, there is no deficiency in transparency, and there is no deficiency into how we are advising our client. Thank you.
Thank you. The matters with the task force. Vice Chair Hyland.
I'd like to hear from some of the attorneys on the task force and have them weigh in on this.
Member Hepner.
Yeah, I mean, my thoughts are not necessarily as an attorney, but I have looked over the opinion in the Grossman case, and it does have a bearing on subsection B3 of 67.24, which under the Sunshine Ordinance allows for disclosure of materials that constitute advice on compliance with the Sunshine Ordinance, the Ralph M. Brown Act, California Public Records Act. The opinion, to some extent, invalidates that portion of the Sunshine Ordinance, if not entirely so. So, I'm inclined to agree with the city attorney on this, and it's just a readjustment of how we adjudicate claims that fall under that exception.
Member Rummel, do you have anything to add?
I'd agree by and large with what Member Hebner said. So at least with its application to this case, I'd say the Grossman case decides whether or not they have to disclose the substance of these opinions. I think that much is clear. But it sounded to me a little bit like there was also an issue of the existence of the communications. And I'm not so sure that the attorney-client privilege or the work product, any privilege necessarily covers the existence of the communications. So if there are logs of communications, I'm not necessarily sure, or for example, emails, I'm not sure that, to and from emails with the substance of the email redacted couldn't be released and be consistent with the Grossman decision and the Sunshine Ordinance more generally.
And if I may just add on that point, traditionally in litigation, if items are withheld due to a privilege, you can request a privilege log, and that's statutorily codified, which lists identifying information without disclosing the substance of what's being withheld. So he may be entitled to seek a privilege log under California statute.
I have a question about a privilege log. What would you expect to see there? How could that? Would it be sort of like an itemization of particular things done on behalf of the client, like 15 minutes spent, researching legal precedents, or half an hour spent writing a letter to the task force about this, something kind of generic?
Well, my understanding is that a privilege log contains enough factual information for the person who is requesting the privileged information to assess the validity of the claim of privilege. What that means is, routinely argued over between attorneys, and I don't know.
So it would be more or less informative, and
right,
depending on the practice of the particular law firm or in this case, the city attorney's office. Member Rumble?
I'd also add that it's a litigation tool, right? So it's when two parties are fighting in court. So unfortunately, I don't know how, it would require them to create another document. So I think it's unreasonable. Well, it's not unreasonable. I think it's quite reasonable, but I think they're not obligated to do it under the PRA or under the Sunshine Ordinance. But I think what they could be obligated to do is make a copy of every email that contained legal advice and redact the actual legal advice, but disclose the fact of the communication of legal advice. They could do it in a way, that it might save them time to make a privilege log instead of going through all that business of printing and redacting and disclosing. But I think a privilege log is a useful tool, but I don't think it's one that we could make them do.
Okay, so just to sort of set the context here and how I've come to know about this issue is that, and please correct me if I'm saying anything wrong here, but the street artist program is completely funded by the street artist fees. And so the fees that are collected from the street artists pay for the staff that administers the program, and also would pay for any consultation of the staff with the city attorney's office. Sometimes there's quite a lot of money spent in consultation with the city attorney's office. This money is charged to the street artists. So I think it's reasonable that the street artists, since they're paying the city attorney, to want at the very least, what you're talking about. At least these emails were written, this letter was written, it took this long to do it. We get really lengthy legal analyses from the city attorney's office about the street artists, about these efforts over the years to find out what's happening, some accounting of what's going on in the street artists program. So to me, it seems like it's only reasonable that that the street artists would want to know, okay, why are we spending so much money? And some accounting other than 4 hours or so on some public records request. So that's what we're trying to get at here, and it seems to me there might be a way to do this through okay, we can't tell you what these emails are about or anything like this, but they exist. And so then the street artists would know, oh, a lot of these emails are being, I don't know, some accounting somehow. Member David.
Yeah, I mean, I think you make a fair point. I think, though, right, every taxpayer pays for everything at City Hall and local government. And so then to extend that argument to, therefore, every taxpayer should be able to get, these documents where a case just kind of made its, the attorneys just kind of said that we have to maybe readjust the way that we look at this particular section of the sunshine. I just think that it's public, it's all public money, whether it's the street artist or whether it's a San Francisco city taxpayer, and so I think that the best that we can do is follow what the court has told us, and we can certainly request, that the city attorney consider making that available. But it seems to me that there's very little ambiguity, and from the two attorneys about what the result of the Grossman case was. So I would ask further. Yeah.
Member Rummold.
So there's very little ambiguity about the substance of the communications, right? I grudgingly acknowledge that. I will reiterate that the Arts Commission is free to waive the privilege at any time, and so they could disclose this stuff as a discretionary matter. It's not, no statute or rule requires them to keep it secret. This is their choice, and they're entitled to exercise that. But I think best practices would be to disclose it. But it's up to them. But that brings us to the second question, and that's whether the existence of the communications can be withheld, and that's what Member Hebner and I were talking about with the privilege log and some way of disclosing that. So actually, I'd like to ask the city attorney whether or not the city attorney's position is also that the existence of these communications is privileged.
No. We will produce and have regularly produced upon request an accounting of the number of hours spent dealing with, first of all, billed to the client, the Arts Commission, and second of all, specifically for the Arts Commission, which we don't do for other city departments and policy bodies, we have created separate entries just to satisfy members of this task force, separate entries that deal specifically with Arts Commission sunshine requests, Arts Commission records discussions. This was before many of the members of the task force were on the task force, but we created these new designations just to be a little bit more accommodating when it comes to the Arts Commission than with other city departments and policy bodies. And I'm holding this in my hand. This is what we can, minus the comments section. When somebody says how much time was billed to what program, we must produce this, we have produced this, we will continue to produce this.
But what about emails? Is it my understanding that you are communicating your legal advice through emails in general?
It can be communicated through email, on the phone, or theoretically in person, although I doubt that would happen very often.
Right.
And I mean, if emails exist and someone's, Mr. Clark or somebody else says, can I have copies of all emails between this and such pertaining to this and such, then we will produce those, although they are going to have to be redacted.
Right. Yeah. The substance of them would be redacted, but the fact of the communication.
The fact that the communication exists, would not be subject to that redaction.
And has the city attorney's office produced? I mean, I assume you have not produced.
In the past. Now, I think Mr. Clark may be frustrated with the fact that that he says that there's a policy, and I don't think that's correct, of conducting these kinds of consultations by phone. I don't think there was a point at which there was a policy change. I don't think there was a formal policy this way, and then I don't think there was a formal policy this way. I could be wrong about that, and I will ask whether there is a written, whether there is a formal policy pertaining to what method of communication is used. I really don't think there is one.
But even if it was done by phone, you'd have a record of. We'd have
a record.
When there was.
A record of when it occurred, how long it took, and how much money it cost. Although I don't know whether, and I think there may also be, I don't want to say something here that's not true, a specific indication that of the method by which it is, the method of communication may be indicated somewhere. I don't see it on this record here, so I may also be wrong about that.
Okay. Thanks.
Vice Chair Hyland, yes.
Could I ask Mr. Clark a question?
Yes, sir.
Did you receive, or did you ask, and have you received any of those redacted email chains?
I asked for all communications to begin with and received no emails in this matter.
Redacted or otherwise?
Redacted or otherwise.
Okay, thank you. Thank you.
Okay. And if possible, I would like to have a minute or two to respond to what's been said by the city attorney.
Mr. Clark, would you respond now? I also just wanted to ask you, too, have you asked the Arts Commission for emails from their end?
Yes.
Have you received anything
No,
from
they're
them?
refusing because he said it's attorney-client privilege.
Did he explain to them that they could in fact
I assume
release them to you?
I assume he did, but they took his advice and refused to give me that information. And because, first of all, he just, in the previous hearing, you were told by the city attorney's office that they do not keep a phone log for any phone calls that they made. They claim that all the advice was, or gave the illusion that all the advice was given over the phone. Now he in response to his question, he just told you that he does keep a phone log of this, and this. In this previous meeting, he said, no, there is no phone log, there are no records, and all I'm doing, and what I'm claiming, I'm not opposed to the attorney-client privilege per se. I'm happy with the attorney. I recognize that. I'm just stating that in this particular case, all the way the law reads is that I'm entitled to this information, or at least some information. As you stated, see, I pay for Mr. Lazar's salary. I pay for the consultation through my certificate fee, and as such, when Howard and the Arts Commission asked for advice from the city attorney, he's acting as my agent. The Arts Commission is maybe the clientele, but he's also my agent. Because I'm paying for any information, any time that he spends. So there is an agent association here, between a legal association, that he's acting as my agent, and as my agent I'm paying. As you can see, there's numerous hours on these things that we have no indication of, and all I'm saying is there's got to be emails somewhere. I didn't say it was an official policy of the city attorney. I just said it's a policy, and that policy is that they send emails back and forth to each other. The city attorney, when this case was first heard, said he didn't have any records, no emails. He said all this was done by phone. And then when I pointed out that, gee, don't they have a phone log somewhere of phone calls? Then they said, no, we don't keep any phone log. Now, they don't keep any emails, they don't keep any phone log, they don't have any other information other than this record, and I'm paying for all this is being included in my certificate fee. And I think at the very least that there should be some slight information, like if we met on this particular day, it was in regards to this complaint number, then I can go search the complaint number. If there was something there to indicate what these things were for, then I could always go back to you or something else and follow up and find out more information, perhaps. But right now, I feel that I've given you prima facie evidence, the smoking gun that shows that there is all these consultations going back and forth via email. Those emails were received as a result of a different case which was heard in front of you, where they were forced to produce those emails. And I think that they indicate that it's only logical that a proper, efficient way for a city attorney to talk to a department regarding sunshine is through emails. So to state that for a whole year there's not a single email, yet there's what we counted up like 47 conferences, and that does not include the conference that I pointed out to you, which isn't in the case. That this is highly suspicious that that this information is being withheld from you. And I'd like to know if the court case that was just determined is being appealed by Mr. Grossman, because if it is being appealed by Mr. Grossman, perhaps he could win it on appeal. I haven't seen the case. Nobody's bothered to, make me aware that the city attorney didn't send me a copy yet saying anything. But I'd like to know if that case is being planned to be appealed.
Okay, thank you.
Sorry for taking up so much time.
I have a question for our attorneys regarding the Grossman case. So the Court of Appeals, it was not upheld. Is that the end of it? Could it possibly go further? I mean, does this mean that we can't cite Section 67.24B3 ever?
So what I would say is that the city attorney can withhold legal advice given to clients about compliance with the sunshine test or the sunshine ordinance now. And so citing that provision of the ordinance, I mean, we can cite it, but using it as a basis to, find someone in violation, I think is not practical going forward. In terms of the Supreme Court hearing it, I don't know if the Supreme Court would take that case, the California Supreme Court. But obviously they can petition, but it's up to the court to decide whether or not they hear the case.
Okay. So for now, we have to operate under the assumption that that particular part of the sunshine ordinance is not enforceable. 6724B3, that the city attorney can withhold information regarding their advice about compliance with the sunshine ordinance, the Brown Act, everything. Okay, but on the more narrow issue of, well, there are two things. One is, what did the city attorney tell the Arts Commission about what they can do regarding communications records about the city attorney's advice? And then also possibly providing information like a privilege log, but some accounting of, these are the records we're withholding from you. We can't tell you what's in them, but we can tell you they exist. And is that something we could request that the city attorney provide?
Yes, I absolutely think so. And I don't think it's covered by the attorney-client privilege, and the city attorney seemed to agree that it wasn't. So I think it's entirely reasonable to say that the emails should be produced, although redacted.
And a phone log, if there is such a thing, showing that phone calls happened on a certain date okay. Member Wolf?
I mean, at the same time, doesn't that mean that the request to the Arts Commission also should have yielded emails that have been redacted? And at this point, as I understand it, Mr. Clark requested this communication from the Arts Commission and has not received anything and should receive these redacted copies from whatever agency he requests them of.
Correct.
And that begs the question, is there a willful violation here? And that's the next thing we need to consider.
Okay. Member David.
Okay, so, Mr. Zitron, do emails exist in this situation that have not been redacted and produced?
No, I mean, I think we received requests from, first of all, I want to defer very briefly to something that Mr. Clark said earlier, which I think he was probably right. If I came here last time and said that there is not a phone log, then I'm going to defer to him as that being correct, because I would have consulted with Adine Vara and others more recently at that meeting than I would have at this one. So I'm going to defer to that and agree that I must have come here and said, no log exists that says this was a phone call, this was a phone call. And now I've done the impossible and forgotten your question. I'm sorry.
It's okay. I'll repeat it. Do emails exist between the city attorney and the Art Commission on this matter that have not been produced? That can be redacted, that have not been produced.
I am confident, not having the search function available between whether it's Adine Vara or somebody else, that if we were requested to produce emails, we would produce any emails that have been requested. We would redact any information that we felt the attorney-client privilege or work product or other legal principle required us to redact. And we would not simply decline this, or, we would not claim that something exists, that something does not exist, that exists.
I think what Member David is saying is that there has already been a request for that.
And if our response to that request was there are no such emails in existence, then there were no such emails in existence.
I find that very hard to believe.
Which part?
All of it. The fact that there's so many communications between your office and the Arts Commission and that not one of them is an email format, I'm sorry, I don't buy that. So I'm leaning towards having those records produced, and I think the rest of us have to decide on, what we do after that.
I'm looking back at the original order of determination, what we asked the city attorney's office to do in the first place, because that's kind of what we're working from at this point in
I'll
time.
read it if you like. To discuss billing practices and documentation required as support for billing statements. Then I think if you look at the original complaint, I think it probably covers everything, including redacted emails.
Yeah, well, if he asked for the advice, he presumably asked for the entire package. The fact that they may not have to produce the actual advice doesn't, absolve them of the responsibility to produce the packaging that the advice came in. So,
what I'm looking at here is the order of determination did not ask the city attorney's office to produce anything. It asked them to come and talk about their billing practices and documentation required as support for billing statements. That was what we were having trouble with. We have an accounting that's so vague as to be useless, and we wanted to know. You just have public records was discussed for this amount of time, and we were interested in, is there something more that could be said to us? And am I members who were at the EOT? Is that correct? You were wanting to know what could they tell?
Right, but I think this goes further back to the original case where the full task force determined there was a violation. That's kind of where I'm going with this. The fact that any and all communications, I think redacted emails should have been offered up at the get-go.
All right, so nothing was produced. No redacted anything was produced. Is that correct?
I think it depends on whether we're talking about was there a specific request for emails? I'm not familiar with it, but I'm prepared to say, okay, if that's what happened, then there was a request for emails. But if there was if there was a request for an accounting, then yes, records were produced that indicated, because it's a very valid point, as Mr. Clark has made and others have agreed, that they do indirectly pay for this program. But while you may be frustrated with the vagueness, it does, the money is accounted for. The costs are accounted for, and you may be frustrated with, okay, the record that has been produced is vague, But reducing that vagueness would require the disclosing of information that we can't disclose. So I understand you say it's vague. Well, yes, it is. It's the disclosure of a communication between an attorney and a client to a third party. Those are regrettably very vague.
Okay, I'm looking at the original request, and what was being requested was, are there any notes, records, or documents associated with the 27 public requests / Brown Act consultations explaining what the city attorney's office advised the Arts Commission in those matters? So this seems to be a direct request for things like emails, phone logs, anything about the consultation. And so, okay, you can't disclose the substance of any of that, but you are required to disclose that these communications exist, these emails exist. If there were phone consultations and you happen to have kept a phone log so you could, realize that you spent 15 minutes on the phone, you could bill them for that. So all of this documentation, I imagine, exists, and if it does, it should exist with everything redacted except that it exists. Am I making sense, attorneys, other members? Member David.
Yeah, I think you're making sense, but I also do believe that the city attorney did provide logs of the hours spent on, so it wasn't that the city attorney didn't provide anything. I just want to be clear that, that there was a log provided with the hours and, discussed Brown Act, that kind of, very minimal information. So I'm kind of what additional, so we're asking them, we're basically going to try to find them in violation because they didn't provide an email that would be completely redacted with just the to and the from information on it. That's, at the end of the day, what we're talking about finding them in violation for?
Something like that, yes. Because the request was for documentation that supported these consultations. And, to, from, and the date, something that they existed, something to provide some accounting for all of this time. For all of these, there were 27 consultations over a period of a year, something like that.
If that's what the records indicate.
Okay. So about every other week.
Mrs. Zittrain,
Vice Chair Hyland.
have you, in your knowledge, have other departments provided redacted emails in situations like this?
I know that the city attorney's office has at times provided redacted emails. I suppose that counts as other departments.
Okay.
And probably there have been, not knowing of any specific instance, I can imagine, where such a thing has happened.
So would it be unfair of us to find you in willful violation for not suggesting that to your client?
Yes, and you're not going to agree with this at all, I can tell you right now. But if there are records of so many consultations, and we send out a request in response to a sunshine inquiry, and it comes back, everybody says, I have no emails that are responsive to that request, you may not be prepared to believe that there are no emails related to those consultations. But when the other attorneys in the city attorney's office say, we don't have emails that are responsive to that request, I believe them. And you may find it unbelievable, but I don't, because they told me.
Well, then I think that's when we run up against the issue of keeping professional records. How in the world can you bill, so many hours and have nothing, no paper trail, nothing there? That defies, and no phone calls.
Your law firm down the street would be out of business if it operated like that.
I disagree. Lawyers a lot of times will conduct consultations with their clients either by phone or in person. Now, it seems like to find a violation would be to direct us not only to consult, but to direct the manner in which we do that. So you must consult with your clients' city departments, and furthermore, you must do so by email. I don't think that this body should be saying to the city attorney that we have to consult with our clients via any particular medium of communication. I don't know where that comes
from. I think what this body might say to the city attorney is that you should offer that advice that they may provide. First of all, they may provide documents, one, at their choice, and that they also may provide redacted documents. That wasn't addressed at any portion of this complaint, from what I can see.
Which the lack of advice. I mean, I don't personally advise Mr. Lazar or the Arts Commission.
Right.
But when it comes to the attorney who does, I'm perfectly confident that she advises them sufficiently on what their obligations are and what their options are. What is permissible.
Our charter is to spread, sunshine within the city departments, and I think it's important to start with the city attorney's office and say, when you talk to your city departments to provide advice, this is one option. You can show, yes, there were 7 emails in that period. Here they are, completely redacted. That would stop, issues getting this far in this task force, because you've showed it, you've complied as much as you can, given the city, the client attorney privilege, rather than just saying no, there's no emails. I mean, don't you think that would be a good sort of interim step, at least to...
Speaking without personal knowledge of how those consultations went, I'm very confident that advice was provided to the Arts Commission that they have the option of disclosing their communications with us.
All right, but I think what we're trying to argue is that those redacted emails should have been provided at the very first time that the clerk, Mr. Clark, asked for them, at least as an option.
If the response from you're talking about, I'm not sure about the Arts Commission, but if you're referring to the first time that they requested such emails from us, and our answer was that we had none, then again we're back to who believes what. Then you're saying that what should have been provided is something that people have asserted to me does not exist, and I'm prepared to assert that to you.
I guess let me try it another way.
Okay.
It would be nice going forward if the city attorney's office told the departments that it advises that is an option. So in this case, I don't know if we should go back and relitigate the original case against the Arts Commission for failing to do this, but it all stems with you guys telling them what to do and what not to do.
Telling them what they can do.
Can and cannot do. And it sounds to me that they were not told that they could do this as an option.
Again, I was not privy to those conversations, but I have trouble believing that.
They're probably just told, you have the option to reveal this or not. But it would be nice if they'd have said, or you could provide redacted emails. I mean, we're getting to the nitty gritty here, but it would be nice going forward. And this might be something that, goes back over to EOTC, but it would be nice to have this conversation with your department and have an understanding, and you guys have complied on some things, but this might be something that might be worth taking under advisement going forward.
Okay, so basically in consultation about sunshine matters with city departments to say, look, if somebody makes a sunshine request to you, yes, you are entitled, but you do not have to. You may release these things, you may release redacted emails just in the interests of transparency.
I think that would have maybe moved things along a lot quicker than having to deal with it at this point, yes.
Member Rummold and then Member Wolf.
I also think that the question of releasing the two from subject line, that's not, I don't think that's a question of discretion. I think that's mandatory, right? I don't know what assertion of the attorney-client privilege would cover that type of information. So I think that should be a part of the advice too, right? You can withhold confidential attorney, whatever the test for attorney-client privilege material is, advice rendered based on confidential information provided by a client, right? That's what the attorney-client privilege covers. It doesn't cover the date that an email was sent, or who, to whom and from whom the email was sent.
And I think in practice that kind of happens, maybe not in a way that's being totally satisfactory to you guys. It happens in when things are revealed that on such and such a date there was a consultation on this subject that took this many hours and thus cost this many dollars. And beyond that, I'm just concerned that you're beyond that, if I come back here, if I go back to the city attorney's office and say, does anybody have any emails? And they say no, I'm kind of at an impasse because, well, I said that to the task force and they just flatly said they didn't believe me.
Well,
so
maybe you asked if anybody had any non-privileged emails.
No, we don't.
No,
that's not the way. That's not the way
was
requests
there an
to
email
lawyers. Do you have any
communication
emails that are
between the
responsive to
city
this? If somebody says yes, but they are privileged, then we don't produce the to from, but we will say in our formal response, we say we are in possession of some records that are responsive to your request, but they are subject to, maybe it's attorney-client privilege, there are other ones as well. So I think the way it actually works in practice, I don't think the dates and times of such things are listed. But their existence is listed. Their existence is acknowledged in our formal response if that happens.
Member Wolf.
So it was basically starting with what Member Rummel just said, but I'm really confused about something, which is that, so the Arts Commission at some point asked the city attorney's office whether they needed to reply with Mr. Clark's request. And if the city attorney's office isn't in possession of an email, that would mean that they had to have asked in person or by phone, or else there'd be an email. So is the records of the phone calls made within the city hall a public record, or?
Well, that's what they were asking about before, and I may have answered incorrectly, and I'll defer to Mr. Clark's answer, which is that my answer before was that there isn't a log of what is formerly phone calls. When somebody gets off the phone, they notate that there is a phone call. What there is, however, is the record of hours spent and on what subject.
Right, I understand in terms of the city attorney's office, and you probably aren't in a position to answer whether or not the phone records,
literally
the
to sort
actual
of
phone records should exist that show who called who and when. And
I think it was probably kept by phone companies rather than by a public body like the city. I don't think, for instance, if somebody said, can you give me a phone log of the phone calls that I've made from my desk, I wouldn't have the first idea of how to go about finding that out.
All right, great, thank you.
Members. I'd like to move this item along. Does anyone have any ideas about how to proceed?
Well, so
Member Rummel,
I'm
please
sorry.
help.
I'm just going through this time log, and I see stuff like category memo, March 20th, 2013, and if that, has that memo been produced, and has it been produced in a redacted way? I mean, that's kind of what I think we're talking about here. How was that memo transmitted? Was it, presumably it was emailed to, maybe it was just a memo for the file, but even still, that could be produced, and it can be produced in a redacted way. So, do we have a way of being like, why don't you go back and double check and see if there are actually records that can be produced in some type of redacted way?
So you're suggesting we might ask that this be done?
Yeah, is there a vehicle through which we can do that? I don't know.
We can make a motion that I believe with. Okay, this is a tricky one for me. So we could refer this matter to compliance and amendments with a request to the city attorney's office that they go back, look for responsive, emails, also any document that was produced after spending 2 and 3/4 hours on something, as I saw in one day. Is there some document that's the result of that?
Right.
And give us an accounting. I think we could ask that they do that and come to the compliance and amendments. So, do you so move?
Yes, I so move.
Is there a second?
Second.
Okay. Now, I'd like to open this for public comment. I'm
We get.
Excuse me.
Get a repeat of what the motion actually is.
Okay. Member Rummold, would you craft this in a way that it's clear to everybody?
Well, I think you said that we would refer it to compliance and amendments to ensure or ask that the city attorney go back and review its records to see if anything listed in this time log has documents associated with it, and whether those documents can be redacted and released in light of, in light of Grossman.
Plus the phone log, I think that was something we
Yeah, if a phone log exists, yeah.
I think we can be more stronger and say that they are to produce in redacted form all documents, including emails, phone logs, that pertain to the matters listed in the time log for this matter.
Yep, all records, sure, yeah.
Yeah. And the second approves this fine-tuning of it. Okay, now,
Public comment.
public comment on this.
Hi there. The street artist program is a mess. It's no news to anybody. Just look at these 4 active permits under 4 different permit numbers issued by the street artist program. Why? I don't know. What it's about? I don't know. Every time I send an email, I don't get a response. That program is run by Howard Lazar. He seems to have done whatever he's wanted for 44 years. He really doesn't account to anyone. He has a boss, Rebecca Krill, who's told me on numerous occasions by phone she's a little too smart to do it by email, that she really can't supervise him. And so any communications that take place, and I was present at the clerk's meeting where Lazar came in and you guys asked him, well, where are your email communications with the city attorney's office? Oh, I don't know. Maybe it was a short email saying, call me. I don't really recall. So as far as accounting and record keeping on the part of the Arts Commission, I assure you the place is a mess, and we all know that. It's nothing new. As far as this kind of time sheet from 2012 to 2013, 21 of these entries had nothing to do with sunshine requests. This was when Howard Lazar on his own fabricated a stalking event against me. It was a bogus claim that I followed him on a trolley. I said something
Ms.
on...
Datesh, please just respond.
Stick to it. Okay, out of these logs, 21 have nothing to do with sunshine requests. You can see it because Aideen Vera is the attorney of the city attorney that advises the Arts Commission. Kim Bliss advises on stalking or harassment issues. The investigation entries of a Richard K-U-N-G is a guy who was hanging around the Sutter Street Post.
Again, could you...
They were irrelevant to sunshine requests. And you were correct in saying that my program fees are paid to bust me over bogus complaints. And what little information that has come in the form of these entries, 21 of them are unrelated to sunshine requests. So you can see from both sides there's no transparency on the part of the city attorney, and there's I don't know if there are any records on the part of Howard Lazar. I would suggest that a lot of it was phone consultations, and so in his handwritten entries. So there's really no record on the part of the Arts Commission either. So, as far as trying to get some information, it's next to impossible.
Robert Clark. First, I'd like to remind the task force of all the emails that my brother put in the file that were sent back and forth from the Art Commission to the board to the city attorney, where they were discussing sunshine things. And now all of a sudden, I guarantee you, I'm not going to not support your motion, but I can guarantee you the city attorney is just going to come back and say, well, we have no records. We know we don't have any emails. And I'm suggesting that that's an outright lie, because the previous years they were having no problem emailing, and now all of a sudden they have no records. And I just think that, I honor you for trying to solve this problem. I don't think it's going to solve it. I think what I would like to say as a person, as a street artist, is that I find it awful shady that my director meets with the city attorney on issues that concern myself and other street artists that we pay both their fees to meet, and then I don't care if they have an attorney-client privilege in the largest sense of things. Mr. Lazar is meeting with the city attorney on my behalf, on the street artist's behalf. We pay his salary. The city attorney is meeting on my behalf. We're paying his salary to meet with the Art Commission, and to have them turn around after they meet about something and say, well, but really we can't tell you what we discussed, what it was about, what we advised you, because we have this blanket attorney-client privilege. And then to turn around at these meetings and try to make my brother look like he's some kind of horrible person who's attacking the attorney-client privilege that supports the foundation of this nation is outrageous on the part of the city attorney. I just don't see why the city attorney and the Art Commission can't turn around and say, well, yeah, we talked about this item, this is the advice we gave, because they're both supposed to be working on my behalf. This is not some outside court case where I'm going to run up to the attorney after the hearing and I'm going to say, I'd like to know what your client said to you in private. This isn't anything like that. This is us going to Howard Lazar saying, we have problems, we want you to talk to the city attorney about it, and then when they talk to the city attorney, we have no way of verifying, one, whether that was actually what was said to them, and two, how much time they actually took to deal with these issues. So therefore, I think that the subject, at the very least, the subject has to be included, and some final opinion of what they're advising them to do has to be included in their books in the future.
Thank you.
Thomas Piccarello. The frustration expressed by Mr. Clark is well placed. The motion by Member Rumgold is weak, and I am strongly in opposition. What's in front of you tonight is a referral by the Education and Outreach Committee to the full task force for a willful violation. Yeah. And I strongly advise you to make a finding of a willful violation. The city attorney has lied to you, and perhaps, you need to take notes when you have conversations on these cases, because you sure the hell is not going to go listen to 6 hours of tapes that occurred 3 months ago. So it might be beneficial for you to take notes. What the city attorney told you previously in front of the full task force, these documents didn't exist. Today he's telling you they do exist, after he was advised by 2 attorney members that there is a privilege log, and that is not work product. So, based on the discussion now of the 2 attorney members of this panel, he says the documents do exist. Well, he's playing games. You should find a willful violation as recommended by the Education and Training Committee to the full task force. Sending it to the Compliance and Amendments Committee is not helping Mr. Clark get the documents that he requested 5 months ago. Thank you.
Thank you. Is there additional public comment?
Richard Nee, I'd like to offer some thoughts that perhaps could inform your discussion. There are really a couple of issues here. Number one, the violation that's been alleged, which is 67.12 29-7. Okay, that's the first issue. Second issue, I think you have to create kind of a go by the chronology of what happened. When was the order of determination issued? What was the instruction on that order of determination? And when did that 5-day window for compliance expire? And this is something that, unfortunately, I don't have it in front of my eyeballs, so you would know that better than I would. But the thing about the invalidation of 67.24B3 is that 5-day window may have expired and may have been up before the appeal court decision came down, in which case, at the time that 5-day window expired, 67.24B3 was still in effect. It was still the law of the city. So that, I think, is one of the key questions that you have to consider. And if that was the case, then certainly it might be part of what your consideration is in terms of whether a violation was willful.
Thank you.
That date was July 28th, I believe.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. Thomas Aquinas teaches that willful ignorance of what one ought to know is a mortal sin. And I say that in respect to, and the attorneys on the task force can correct me where I might misrepresent this or misexplain this. The state has a tome, a legal tome, which is called CACI or CASI, depending on what you're talking about. And one of the items in there is what judges use to charge a jury and tell them what their responsibilities are and what they are and are not allowed to do in certain cases. And one of the sections in there talks about the fact of production of records. And it says generally that when there are parties, a disagreement between parties, and one of those parties could have produced better records, that it is reasonable for the members of the jury to assume that the records would have been to their detriment. In other words, they didn't want to produce the records because they were harmful. And what I'm saying in this particular case is the reason that the Arts Commission doesn't want to produce these records is because they would be harmful to their position. I empathize with the Clark brothers because I've been to some of the street artist meetings and I've heard the comments made. They use their attempts to get documentation to find out where the hell the money's going as a way to cut them off from other members of the Street Artists Commission. They say, oh, we're paying all this money for this legal advice and it's only because you file these sunshine cases. And so it's this kind of have it your cake and eat it too. Let's not tell you what advice we're getting from the city attorney, but let's blame you for the fact that we have to go to the city attorney and get the advice. And then let's use that against you to say, well, it's your fault. We're having to pay these attorney fees because you're out there trying to get your rights respected under the law. It really is, the Arts Commission is a bunch of liars. Very frankly, I sat in one meeting where they told Mr. Warfield here that one of the commissioners sat there and said, I don't know who you think you are, but I'm going to see that you don't have any right to come to these meetings and make these kinds of comments. They don't respect the public. They don't respect the public's right to know. And the Street Arts Committee is run by a man who I basically honestly feel is senile. He's been in charge of that program for more than 40 years, and he shows up at cases. He showed up at the Board of Appeals, and they, in public, said to him, we are amazed that you keep such horrendous records. They did, in that case, try to put together a case against Paula Dadish. But basically, something needs to be done to say the Arts Commission, tell them where the money's going. It's their money.
Patrick Manetshaw, here on my own time as a private citizen. I'm hopeful that members Hepner and Rummel will keep advising the task force on legal issues. It's nice having both of you on the task force after that long drought of no attorney representation. But with that said, Member Rummel, I'm hoping you know of Lily Tomlin's comedy routines. One of them, she is admonished by her school teacher, "Hold your horses, Lily." I'm asking you to hold your horses until Mr. Grossman makes up his mind on whether he's going to appeal to the Supreme Court and whether the Supreme Court will accept the case. As far as former task force member Rick Nee's comment about 6724B3 and whether it's still the law of the land in San Francisco, I believe it will be until the Superior Court schedules a hearing that it was ordered to by the appellate court and actually issues some sort of new order in Mr. Grossman's case. That has not happened yet. So from my perspective, 6724B3 will remain applicable until such time as the Superior Court takes its next step. Now, you don't have to respond to me, Member Rummold, but it would be helpful if you would let me know if my perspective is way off base. As for the Arts Commission itself, I see they've been to the Willie Brown School of let's withhold records. He's given that advice to Jerry Brown. Never hold records. And it appears to me that that may even be some of the advice city attorney follows, that they're keeping no log whatsoever of records that were produced in this case so far and whether they were redacted at all. The trick is keep no records, because then there's no audit trail.
Thank you. Is there additional public comment?
Peter Warfield. The case is one, unfortunately, which I'm not as familiar with as I would like to be. I'm not a party to the case, but certainly I think all of the previous comments were very worth hearing. I think there's some really counter to public purposes issues here. They're going to not say anything about what they spent money on, and meanwhile squeeze the folks who are asking for some information. The Clark brothers, who simply want to know what's going on, are going to engender massive expenditures so that everybody can blame them for the costs going up and their money being used up for legal expenses, where meanwhile there's no record of what was going on, what was being discussed, or even any documentation concerning anything about the subjects and where it was going. With respect to the discussion about 67.24, I would like to remind the task force about ongoing and years-long violations by the city attorney of 67.21I. And it seems to me that even if you would let the city attorney off on consultations, there are specific prohibitions against the city attorney acting in certain cases. The city attorney shouldn't even get involved. So here's what 67.21I says. The San Francisco City Attorney's Office shall act to protect and secure the rights of the people of San Francisco to access public information and public meetings, and shall not act as legal counsel for any city employee or any person having custody of any public record for purposes of denying access to the public. city attorney may publish legal opinions in response to a request from any person as to whether a record or information is public. And then it goes on again, all communications with the city attorney's office with regard to this ordinance, including petitions, requests for opinion, and opinions shall be public records. So I'm very concerned and curious whether you have already considered whether the city attorney should simply not be advising the Arts Commission or anybody else and simply say, we can't advise you with respect to withholding documents. And then there wouldn't be any question about whether or not this legal case or that legal case invalidates this or that section of the Sunshine Ordinance. Thanks.
Thank you. The matter's back with the task force. Is there any additional discussion? Member Wolf.
I mean, I don't think it's within the grounds of the Sunshine Task Force, but it seems like if Mr. Clark is paying the dues for this legal consulting through the city attorney, it seems like there should be some legal right. That's not the right of the public to access this information, but his right as a member of the Street Artists Commission or something. But I don't think that's within the binds of the Sunshine Task Force. But I'm curious if anyone on the task force has any perceptions in terms of whether there is some sort of legal principle outside of public records that should entitle him to this information.
I have to say I've had the very same thought from time to time. There's something very different about this. I have to say that I've thought about this whole situation a great deal over the years. And I also want to thank Mr. Warfield for bringing up 6721I. This is certainly a provision I'm familiar with, but had forgotten in this context. But again, how would we know whether or not this is being complied with without having some bare bones information? Anyone else before I ask for call of the roll on this motion? Member Hebner.
I'll just say that after listening to public comment, first of all, we're not making a motion or potentially finding a violation as to the Arts Commission. The city attorney is the respondent in this instance, which I think is worth noting. And I think that the idea of referring to compliance and amendments is a really good and strong idea. I think this is a really good opportunity to get on the same page with the city attorney's office as to how to approach these things. And this is something that's going to come up again and again when we're responding to the grand jury report, is getting on the same page with the Ethics Commission and the city attorney's office with respect to how we're enforcing these sections and trying to find room for collaboration. I think this is a really great opportunity for that.
And you will be having more to say about it as...
Probably.
Yes, okay. So member chair of that body. So at this time, Mr. Young, would you call the roll on this motion?
On the motion to refer this matter to the Compliance and Amendments Committee to request that the city attorney's office provide any documents pertaining to this matter in a redacted form. On that motion, Member Rummold.
Aye.
Rummold, aye. Member Winston.
Aye.
Winston, aye. Member Wolf.
Aye.
Wolf, aye. Member Hepner.
Aye.
Hepner, aye. Member David.
No.
David, no. Member Fisher.
Aye.
Fisher, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes. This matter will be referred to the Compliance and Amendments Committee.
And the discussion will continue. I hope we'll make some meaningful progress on this. There's some other, the whole issue of the Grossman case too is something we need to continue to monitor and make sure we understand that we're moving or understand the status and what to do in regards to that. So at this time, we're way past due for general public.
Item number 6, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction but not on today's agenda.
Ladies and gentlemen, William Clark again. Since we just went through my case, I would like to suggest to you that in the future, if a case is sent to a committee and then comes back in front of the full board, rather than putting that case at the end of the calendar because it's an older case, that those cases should be heard at the beginning of the calendar, because as you can see in my case, had Anonymous held her case here, I would have been here all night long until you finally got to me. So what I'm suggesting is that if a case is heard at committee and it does get sent back in front of the full task force, that when it does get scheduled at the full task force, it be scheduled ahead of any other complaints that are higher in number than what that original complaint was. Thank you.
Thank you.
I just want to kind of update you on the type of harassment that I'm under. Not that it makes any sense to you, but this is the street artist isms. Justin Herman Plaza is a place where a number of these street artists set up. Okay, you have to go there at 6 o'clock in the morning for a lottery. I have only gone there 4 times because the market manager, somebody who I don't know and never spoke to, has harassed me so much. With claims that I'm the sole cause of the fees going up for making sunshine complaints, that my requests for information are driving the fees up. He's even circulated a petition to people who I don't know, asking them to sign it. He's called the police on me repeatedly, harassed me to no end. I actually took him to court last year. He was yelled at by a judge. And he's doing court again on August 22nd. I don't know this man. I've never spoken to him. And his harassment extends to other parts of the city outside of his jurisdiction. So it has not been easy on me in any shape or form. None of this makes any sense. It's just stemming or emanating from this one man, Howard Lazar, who basically has done whatever he wants for years. He goes out under the guise of an inspection and babbles and gossips and creates whatever drama he feels like creating. And it's really affected me economically, and it's not been easy. Makes no sense at all, but it is what it is.
Micah Ringel. I am here to report that on July 28th, the Ethics Commission held a public hearing regarding ethics complaint, which was a referral from the Sunshine Ordinance Task Force, Sunshine Complaint number 13024. The Ethics Commission found by a vote of 4-0, in what I believe is unprecedented for finding a department head, that Director John Rahame, Director of the Planning Department, committed a non-willful violation of Section 6721A of the Sunshine Ordinance by failing to permit public records to be inspected and examined without unreasonable delay. The Commission also found that Director Rahame did not violate Section 6729.7 of the Sunshine Ordinance, but the fact is, he was held accountable. And I want to thank you all very much for your helping me get there. And to you, Member Nee. And so, if I can, this is the quintessential part of the hearing, and it's the audio from it. And the person speaking is Member Keene, who is, coincidentally, the Deputy City Attorney's appointee. Volume.
Comment, and then I'll have a motion. And that is, I think people of San Francisco owe a debt to you, Mr. Ringel, because for going and pushing this rock up this mountain as you have, because I think for all of the people like yourself who get to this point, there have probably been hundreds who've given up. And haven't, have not been given the information that they're entitled to under the California Public Records Act and under the San Francisco Sunshine Act. And it seems that you're bringing this to the attention of the city as you have. You've done a service to a lot of people. I want to thank you for it.
Thank you very much. That means a lot to me, really. Thank you very much.
I have a motion. Mr. Chair, I move that we find that Director John Rahame violated the San Francisco Administrative Code Sunshine Ordinance Section 67.21A, that as custodian of the records, he did not, without unreasonable delay, permit a public record to be inspected and examined.
And that was a unanimous decision, so I want to thank you all very much for helping me get there. And thanks. Thank you very much.
Thank you so much for sharing that with us. There are big smiles up here. It's very gratifying to us. Sure, absolutely, yeah.
You know, I actually chaired some of those meetings you were here, and I just kept looking at you, and I remember calling you the accidental activist, and I have to agree. I mean, it was like Sisyphus pushing that up the hill, and I want to thank you for really sticking with this. I say that to a lot of people as they come through these doors, and, you know, maybe you're 30 years younger than me. You have more strength than I do. I don't know if I would have, but your case really stuck with us all. And I'm glad that you had a good outcome. I hope whatever happens with the building or whatever is, you know, also works out for you.
Yeah, no, I thank you all very much. I've thought about you all often. And I believe you wrote a story about part of the Potrero Development Sunshine Ordinance Shadows.
Oh, yeah.
By Josh Wolf. Yeah, that must be you. I was going to say, I think we've talked. And remember, David, you weren't at the last hearing, but what you said really was encouraged me, and that was, I'm not bothered by a lot of things, but I'm bothered, this bothers me. Mm-hmm. And I thought that was so strong and so spot on. And yeah, Member Fisher and Member Washburn and Member Highland and Member Oka and Member Nee, I thank you all very much for your help. Thank you.
Thank you again.
Hundreds have given up indeed. Good afternoon. My name is James Chafee. I was an inaugural member of the Sunshine Ordinance Task Force, its first vice chair and its second chair. The 20th anniversary of the Sunshine Ordinance Task Force was last year. No one noticed because no one had anything to celebrate. In fact, it's been deeply humiliating that our efforts to lay a foundation for sunshine in this city and a successful Sunshine Ordinance Task Force have resulted in such abject failure. There is a famous quotation, usually ascribed to George Santayana, but it can be attributed to any number of people with slightly different formulations, that those who do not remember their history are destined to repeat it. One of the things that always repeats itself is that we always get Sunshine Task Force members who think that doesn't apply to them. In June of last year, I complained about the Board of Supervisors budget process, which had disenfranchised the public and violated the Sunshine Ordinance in numerous ways to separate people's input into the budget process. That was endorsed unanimously by the Sunshine Ordinance Task Force. That is, it was endorsed unanimously among all those people who use reason and evidence for their vote, which means, of course, everybody but Todd David. Now, you will look in vain in the annual report for any mention of the determination and the verification of these violations. The reason is because it was referred to the Compliance Amendments Committee. It was not referred to the Compliance Amendments Committee. It was referred to the Education, Outreach, and Training Committee, and thereby disappeared. Now, that was presumably by Louise Fisher. The committee is chaired by David Pilpel, and on it is served Todd David. Now, when you got to the Rules Committee of the Board of Supervisors, you found that those were the 3 people that were full-throatedly endorsed by the Board of Supervisors for this task force. The rest of you were continued in the hopes that they would find someone even stupider. Well, in fact, this is not trivial. Do you read the newspaper? We live in a time when the assets of this public society are accruing to fewer people. Public sector is being destroyed, public participation is being destroyed, and the destruction of our history is a very important part of that. Thank you.
Thank you.
Richard Nee. I want to take issue, first of all, with something that Mr. Monette Shaw said, and that is that for 2 years the task force was without an attorney. It is true that seat number 1 was vacant during those 2 years. However, we did have an attorney on the task force, a gent named David Sims, and I think he did an admirable job. I want to talk about 67.24B3 for a minute. Right now, it's invalidated. However, there is from time to time discussion of whether the task force wants to attempt to put together a reform package for submittal to the Board of Supervisors with a request that it go on the ballot. If you do that, I would strongly suggest that 67.24B3 not be stricken therefrom, that it be left in, because there is a severability clause in the ordinance. I think it's 67.37. Maybe I'm 1 or 2 digits off on that, but there is toward the end of the ordinance a severability clause. And if the so right now, with that severability clause in there, of course, the rest of the ordinance remains intact. But if the if at some point a court decides to reverse the appellate court decision and uphold the Grossman decision at the Superior Court level, 67.24B3 is still there. It's back in. Another possible route to reinstating 67.24B3, a charter amendment. Difficult to achieve, but worth considering. Also, an amendment to the California Public Records Act, because the charter cannot supersede the California Public Records Act. Worth considering.
Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I've been involved with the task force for probably 5 or 6 years now, and just to let those of you who are new know, I have gotten 17 orders of determination, which is a 75% success rate. In other words, the cases I file are not frivolous, they succeed. And one of the things that I have learned very, very clearly in attending public meetings, especially at the Library Commission, the Arts Commission, the Police Commission, and the Board of Supervisors, is that our civil liberties are under attack by the city. I have had the president of the Police Commission tell me that there were certain things I was not allowed to talk about. I've had the former president of the Library Commission call the police and say she felt threatened. I've had, you go there and you sit and watch, and I don't just go for my own benefit, I go and watch what goes on procedurally with all of the members of the public. And it is amazing how many times members who took an oath to support and defend the Constitution of the United States and that of the state of California will sit up there, look a member of the public in the eye, and lie through their teeth. Tell them that you're not allowed to talk about that. You're not allowed to do this. And then they equivocate. Now, just recently, to sort of talk to you about my success rate. 6 of my orders of determination were eventually referred to the Ethics Commission, and they have managed to dismiss every single one. But they've kind of gotten to the point where they don't know what to do with me, because the last time what they did is they announced the referral the day that I left the state on vacation and had the hearing the day before I returned to the state. And their response was, "Oh, we were surprised you didn't show up too." Now, when it gets to the point where the only way they can figure of dismissing your complaints is to hold them while you're out of the state, you know you must be doing something right. But what I'm telling you is I do these not simply for my own matters. I do it because each and every citizen of this city, including all of you, stand a chance that if you really have something to say which they don't want to hear or don't want heard, you will run up to a member of a board or commission who will tell you flat out in public you're not allowed to talk about it. Or in my case, last October, the president of this Board of Supervisors simply said, "I don't think we're going to let this speaker speak today," because he didn't like the way I opened my public comment. And I've been before the Board of Supervisors several times, and their attitude is, well, he's the president of the Board of Supervisors. He's entitled to strip you of your First Amendment rights.
Thank you. Is there additional public comment?
Thomas Piccarello. First of all, I want to compliment the chair for reorganizing your committees, and hopefully the new compositions of your committees will not allow another order of determination like Mr. Chafee had regarding public comment at the Budget and Finance Committee. As you know, or should know, I filed a willful violation against the same Budget and Finance Committee for violating Mr. Chafee's order of determination. So we'll see what happens with that. I just want to make a general comment to the full task force in that it is nice to have a couple of attorneys on the panel, but I would suggest to them that, many attorneys disagree regarding statutes or case law. So, I urge the non-lawyers on this task force to do their own research and use common sense and not conclude that the lawyers on this task force are the final word. And also, I would encourage you also to rely on Mr. Cola. He is here for a reason, and that if there's a legal discussion amongst task force members, Mr. Cola should be involved in that discussion as well. Thank you.
Thank you.
Patrick Minetshaw. I find the last speaker, who has been disbarred, may have raised some interesting, although invalid, points. Mr. Young, would you please distribute this flyer and packet to each member of the task force? It's a flyer titled "The Case to Censure Sunshine Ordinance Task Force Member David Pilpel" under Robert's Rules of Order. Before I go into that in any more detail, I did want to comment that Micah Ringel did succeed at the Ethics Commission. He did not play you back the portion in which Commissioner Keene is heard on tape saying that the Ethics Commission reached the right decision in Micah's case, but had made the wrong decision in the Dominic Maicione case. So my recommendation to you is to turn that referral from ethics, returning Dominic's case to you, and you should return it to the Ethics Commission, telling them that Commissioner Keene noted that there was a disparity between the two outcomes. Just send that thing back to them and make them rehear it. As to the censure issue, the Sunshine Ordinance bylaws specifies you operate under Robert's Rules of Order. Robert's Rules of Order has essential procedure. The Statement of Incompatible Activities provides that task force members are permitted to testify as private citizens before other bodies about issues only outside of their official duties, but are not permitted to testify on issues that fall inside the scope of their duties. Member Pilpil may also be engaging in ex parte communications to the extent that he goes to other commissions without informing either the task force members or the complainants that after you have reached your orders of determination and you have forwarded referrals for enforcement, naming department heads to ethics, he feels entitled to speak as a representative of the task force about matters that you have already adjudicated and that he wants to undercut. So I urge you to quickly hold a censure vote and enforce Robert's Rules of Order so that you can encourage him to change his behavior and stop doing what he's been doing. It's imperative that you do this quickly. Thank you.
Thank you. Is there additional public comment at this time?
Yes, I would like to use the overhead. Is that operating? Okay, I'm Peter Warfield, Executive Director of Library Users Association. I'm glad of all the public comments that have preceded, particularly Mr. Chafee, who won a big decision at the Sunshine Task Force. And I would appreciate your attention to what I'm saying at this time. Not only did Mr. Chafee win his case, but the Board of Supervisors made the exact same violation this year when they did the budget hearings as they did last year when he filed the complaint. That's not what's up here just now. That's a precursor. And with respect to your actions, I agree with the previous speaker as well. You need to be quick because whoever here is good is going to be out of here in 2 years if the supervisors treat you as they did the previous good Sunshine Task Force. There are very serious threats to open government, and one of those is the whole way in which decision-making is being outsourced to essentially secret groups outside or presumably outside the reach of open government law. There was a Bernal mural on the Bernal Heights Branch Library, and you've seen me, those of you who've been around, on a number of violations that occurred with respect to that. There is now a new book out, a Beth Roy authored book, The Bernal Mural Story, put out by Syracuse University Press, which is extraordinary hogwash. She treats the whole situation of a community decision-making as just that, and not a public mural on a public library that needs to be treated as a public process. She is the hero riding in like the Lone Ranger to resolve a community dispute and treats it like a kind of group therapy without any apparent understanding of the existence of public process and open government as a way to resolve public issues. This was the order of determination that I got for Library Users Association regarding Supervisor Campos's secrecy regarding information about the process that she was the head of. And this was an example when we asked for information about that process of what we got, literally some 300 pages of redactions like this. City Hall meeting, lots of redactions. May I suggest that we refrain from having substantive discussions via email? The Supervisor Campos said that he was redacting personal emails and contact information. Mauricio Vela had died by the time we got this. Here is Latin Zone Productions, the page after page like this, as though this was a secret operation from the CIA.
Thank you. Is there additional public comment at this time?
Good afternoon, Task Force. My name is Dorian Maxwell. I'm pro-open government. As you know, San Francisco is full of a lot of corruption. And it's best that, even with the MTA and some of the Board of Supervisors and all that Library Commission, a lot of things that goes on, they try to hide it from us. And we come to this body, the Sunshine Task Force, for remedy and get help with attaining information. As the previous speaker, I recently won 2 order determinations that I filed with this. And I was recently retaliating by Muni, the SFMTA, and falsely terminated. I had one of the members go to the Ethics Commission, and I haven't heard anything from that. Haven't heard anything from the Ethics Commission about that. Open government is an excellent opportunity for the citizens to attain the facts to help them make an intelligent decision on bringing back in these crooked politicians and getting rid of them. And that's what we really need to see reform in city government, especially here in San Francisco. And some of these public agencies definitely need to be reformed, where the justice is done for all of us, so we can see how our government is running, where our tax dollars is going. And it's a lot of wasteful spending that these agencies that brings in our tax dollars, and we need to know that. And having an open government and having access to the information, who said what, this said this, and all that, that's important to us. So when we make an intelligent decision at the polls to get rid of these people, and prosecute these people to the full extent of the law for misappropriation of federal public funds and all that. So in closing, this is a good entity. It helped me, and it helps a lot of citizens in the city and county of San Francisco. In fact, I had got an article in the New York Times regarding one of my cases. Actually, a reporter was here, and it made national syndication that this board helps people get what they need. Thank you.
Thank you, Mr. Maxwell. It's good to see you again. Is there anyone else here to offer public comment? Any additional speakers? Okay. I'm wondering if we might move ahead to the next. We have a hearing. I see everyone is here, and then take a break after that. Will that work? Or do we need a break now?
Yeah. It's okay.
This is...
Side of the table wants the break now. What do you guys want?
If everyone else is ready to go forward, it's fine with me.
Everybody wants to go, then I'll...
Member Oka, what say you?
Doesn't matter. Whatever.
Let's Forge ahead then.
Okay, we'll hear the next case, then we'll take a 15-minute at least break, okay?
Item
All right.
number 8.
Yes.
Item number 8, file number 14048, complaint filed by Cecilia Harrison Omandi against Donald Ellison and the San Francisco Municipal Transportation Agency for allegedly violating Sunshine Ordinance Section 67.1, 67.2, 167.25, 67.26, and 67.27 for failure to respond to an immediate disclosure request in a timely and complete manner dated May 7, 2014.
Okay, I believe we first have to decide jurisdiction, and is there someone here from the MTA? Yes. Okay, all right. So do I hear a motion to find jurisdiction in this case?
So moved.
Second.
Any discussion from the members? Any public comment on jurisdiction? Okay, if we could pass this motion without objection. Okay, that seems fine. All right, moving to the hearing itself. First, the complainant, Ms. Omandi?
Yes.
And you'll have 5 minutes to explain to us what has happened here, and then anybody who has any information to support you may speak for 3 minutes. Then we'll ask to hear from the MTA for the next 5 minutes. Then we may have questions for you. Okay? Proceed.
Yes, I was here in February of this year, and apparently I didn't form the questions correctly, and with the support of the panel, I found out how to do it, and I redid the questions and asked for the documents, and I never did receive the documents. The only thing I received is something that I didn't even ask for, and that was a records from the transportation, the training department. I'm sorry, the training department, and a copy of my an application that I'd applied for parking control officer. And where's the questions, the documents that I've asked for? I never received them, and they're there, and they have the documents, and they have not provided them to me, and I don't have anything to really speak on. I mean, because I don't have the documents, nothing. It's just repetitive information that I've already had that I didn't even ask for. And I'm aware of the accident, and in this document it stated that I was not eligible for VTT training, retraining in 2009, which is not true. I had training in 2009. I didn't have training in 2013, but I did in 2009 all the way up to 2012. So I'm not understanding what exactly are they. They have not sent me anything. And also, on the letter it stated that I had to sign a privacy paper, which I never did receive to sign anything. And it says here, well, I can't find it right now, but it did say that I had to sign a paper stating to release due to privacy, that I need to sign the paper, but I never did got a paper in the mail. All I received was this letter here, but nothing was attached stating that I need to sign a signature, a waiver, or anything. So I never did receive any of that. So based on some legal advice, I was told just to go to the task force and let them know that you haven't received any of these documents, and I'm still waiting. I still want them. I know they are there in a file. And they're the only ones who have it. I've seen the documents, and basically Mr. Ellison says he's not going to give them to me. They don't exist. They do exist.
Okay. Thank you. We may have some, we'll undoubtedly have some questions for you later. We're going to, is there anyone here to offer facts and evidence in support of Ms. Omondi?
Good evening, good afternoon, Task Force. My name is Dorian Maxwell. The SFMTA have a histrionic issue with furnishing the employees their information. I had 2 cases that was brought before you that the MTA was withholding documents that was in my personnel file that they refused to give it to me. Come to find out, after the hearing, they finally went through my personnel file and pulled them up after the order of determination was given to them to give my information. They have, this is their rule book. And in an excerpt, I'm like to read an excerpt from their rule book. It says personnel records is kept of every employee from day he or she enters the service. Employees may examine their full personnel record under the authorized supervision. Records are confidential as otherwise prohibited by law if an employee desires so. An employee representative may be present during the examination. This is their own rules and policies. And Ms. Omondi, she asked for her information, and she saw some things that was in her file from the city attorney, from the Nathaniel Ford. He was the executive director at that time. And she wanted to get copies of this information. And I feel that if anything goes in your employee record, you should be entitled to it under the public information, employees' rights. So where is the justification for the MTA to refuse to abide by their own rules, which is in their policies here? And she's just asking to review her files and get whatever she needs out of her files. And they giving her the runaround that this information is not there. Apparently, something was said, something was done, and something must have been entered to her personnel file, because management at the MTA has changed. And for whatever reason, that whatever is preventing her from getting what she needs to get or whatever she needs to do is in that personnel file. All she's trying to do is exercise her seniority and figure out why she's not able to exercise her seniority.
Thank you very much. Is there anyone else here to offer facts and evidence in support of the complainant? All right. Seeing none, the respondent, there's a representative here from the MTA. Could you state your name?
Kathy Fowlis.
Pardon me, Kathy?
Kathy Fowlis.
Fowlis, okay.
Yes.
Thank you.
Hi. So I'm a little unclear as to, well, first of all, I'm here representing my director. He had a conflict and couldn't attend this evening, Mr. Donald Ellison. So I'm here just with...
Could you speak up, please? Yes.
I'm sorry. So I'm here to answer to the letter of June 3rd that was returned with which regards to some information Mrs. Harrison Omondi was requesting, which was employment, letters, emails, grievances, and telephone cell calls between SFMTA and the local union 250A. Unfortunately, SFMTA does not keep the records for the TWU union 250A. We wouldn't have any of their records. It's not part of Mrs. Harrison Omondi's personnel file. So that's the understanding that I'm here for, that Mrs. Harrison-Omundi was complaining that we did not provide her these records or these documents, which is not within SFMTA's realm to get from a union.
Do you have anything else to say regarding the extent of her request and the specific items she was
As far
asking
as her
for?
employment records and her official personnel file, we have provided Mrs. Harrison-Omundi 2 copies of that. Matter of fact, I believe when we attended the earlier hearing here, I believe that was in February, she actually had copies that was provided to the task force, and we was questioned as to why they were not redacted. So when we provide copies to our employees, we do not redact their personnel files because the employee is asking for the copies.
All right. Do you have anything else to say at this time? Is there anyone here to offer facts and evidence in support of the respondent? Anyone else from the MTA? All right. The matter is now with the task force for questions. Members?
I'm happy to ask a couple questions.
Yes, please, Member Hebner.
Of Ms. Harrison-Omundi. Hi.
Hi.
Now, first of all, I'm going to ask you to appreciate that I wasn't here for your original complaint with the Sunshine Task Force back in February.
Yeah.
But I'm curious. Did you receive a copy of your personnel file at that time?
The last time, only what I asked for.
Okay.
So, but there were other things that I asked for that was not given to me, and after speaking to the panelists, a lot of people that aren't here, he's still here. I was instructed in a roundabout way how to ask for the documents in a roundabout way. So that's why I told him I will come back, and I'm back today because I have restructured the questions, and this time I still haven't received anything that I wanted.
Okay, so if you could just itemize specifically one by one the additional items that you asked for this time, which you have not received.
Okay.
I'm trying to understand the difference between your original complaint in February, the additional items that you asked for this time that you believe you have not received.
Basically, I asked for the same things, but it was the way I was asking them, and they didn't have to present them to me. So I was instructed on how to rephrase the question, the whole questions, and therefore they will, I'm assuming, have to give it to me because of the way I restructured the questions.
Okay, so let's go. I have a list of 12 items here.
Yes.
That I understand to be what you were requesting. This is the revised form of your requests to the SFMTA, correct?
SFMTA?
Right.
I'm sorry, what did you say the first?
These 12 items are the reformatted requests to the Municipal Transportation Agency, correct?
Yes.
Okay. So, just one, if I, for instance, take number 7, or let's go with number 6, official written document stating why I was denied a job position in parking control officer classification 8214. Were you provided with that documentation?
Yes, I was. I'm sorry. Yes, I was.
Okay.
Yes. No, I was provided with the document, but I was not provided as to why I was not hired and why I was rejected. I got it verbally, but I didn't get it in writing.
Okay. So is that request one of those requests is request number 4, official written documents as to why I cannot exercise my seniority.
Number 4 is different from 6.
Number 6, right, correct.
Number 4 is basically, in 2007 when I had my accident, I was given 4 things that I have to do before going back to the bus. One of them I did, and that's 30-day suspension. I can't exercise a 1 year of probation because I have not been on the bus to exercise the probation. So I did ask, why am I not allowed to exercise my seniority? And when I say exercise my seniority, meaning why can't I sign on a run? Why am I being paid 8 hours base pay instead of run pay based on my seniority? Sometimes you let me sign, sometimes you don't. Inconsistent of being consistent.
So this is request number 5 then?
No, this is, you asked for 4.
Right, but you started speaking as to why you are not entitled to your 8 hours of VTT class. Is that?
Yeah, that's number 5.
That's number 5. I'm trying to understand what documents you're still expecting that you believe have not been produced to you. And
can we go from 1? Maybe you can follow me there.
Yes.
Okay. On number 1, if you look on 1, on April of 2007, I was given a judgment by Paul, help me pronounce his name. Chukovich, yes. And that was 30-day suspension, extensive retraining, and evaluation for fitness duty from a medical doctor, and a 1-year probation. In that room, 1-year probationary. When I get back on the bus, if I have an accident and within 1 year, I'm gone. I'm out. Okay. I want to know who authorized this change. Ford at the time, our manager was Ford. He was still with Muni then. He had 7 days to appeal this, but he didn't appeal it. He let it stand. So it was 7 days from the day this man put the ink on the paper, and he did not appeal it. But when I came back to work, there was a whole new agenda, and I was told the city attorney said I can't drive anymore. Okay, well, if you're giving all these instructions, this disciplinary, verbal disciplinary, I need something in writing. I come to work one day, don't tell me, oh, well, you got to do this. Well, where is it in writing? I discipline you, Lee Hepner. You want something in writing. That's your protection.
Right.
And I'm not getting anything in writing. But in 2008, March of 2008, I had to sign another paper to extend my 1-year probation when I didn't even serve the first year probation, and that's when I seen the city attorney paper in the files. Kermit Garn was the manager then, and I seen the letter saying that I can't drive no more. So at that point, I did ask them, I need a copy of this letter. Oh, well, you have to go with your union and get a copy then. Oh, it disappeared. They have files in your personnel at the patrol division. They got one at the union. They had one at the human resource, and they got one other places.
So did you ever receive this letter then?
No.
My understanding is no, you never received this letter.
No, I want the letter. I've seen the letter. And I also want to know who authorized all this punishment. I am getting excessive punishment for 7 years, and they're violating their own MOU. After 1 year, you cannot punish me for the same infraction. And this is a repetitive discipline.
Okay. I understand that and your frustration in that regard.
Oh, you just don't know.
I can empathize, having not experienced it myself, at least. So, if we are to take, for instance, focus for an instance on the issue of why you were not given this letter or any written determination of disciplinary action beyond the written documentation of the 30-day suspension subject to your completion of a retraining program and a 1-year probationary period. You've been disciplined beyond this point, and you don't have any written documentation of why you've been disciplined beyond these measures. Is that correct? Is that accurate?
Yeah, I don't have anything. I can come into work tomorrow and they'll have something new. This is the reason why I'm in this slang right now, because the superintendent said, well, we need you to clean up a receiver's room. Where is it in writing that you want me to pick up these 15-pound boxes? I tore a tendon in this arm. I had to have surgery. Well, Don Ellison isn't going to reply to this, and I've asked him several times, and he doesn't want to reply to this.
Okay, so I'm going to ask a couple questions of the representative from the Municipal Transportation Agency and just try and zero in on, this discrete issue. Hi.
Try to answer. Hi.
All right. Thank you. I appreciate your efforts there. Do you dispute that Ms. That Ms. Hairston-Omandi has been disciplined beyond the disciplinary measures set forth in item 1 here? Has she been disciplined beyond?
I didn't bring any documents with me with regards to item 1.
Okay, so
because I'm only responding to the June 3rd letter. Now, is there something I can look at?
Right.
If it is, I'll look at it.
This
and I can
sunshine
tell you.
complaint dates back to a May 6th request for documents. Is that not correct?
No, I'm reading the letter from June 3rd.
Am I fundamentally misunderstanding what
Yes,
date
because I am too.
Excuse me.
I'm sorry.
Members, I am looking at a request, an immediate disclosure request on May 6th that was responded to on May 9th. Is that correct? And then I have a letter from the MTA on June 3rd,
Correct.
which elucidates, gives some context to the MTA's response. Is that right?
Correct.
So you are actually here to respond to an immediate disclosure request dating back to May 6th that was answered on May 9th.
And those records were provided to Ms. Harrison on Monday.
Right. So, but in that request, okay, I'll get to that.
Okay.
But you are here to respond to her immediate disclosure request dating back to May 6th.
Okay.
In that request, item number 1 requests written documentation of disciplinary measures taken against her, or within the request are written documentation of disciplinary measures.
Correct.
Do you dispute that? So are you prepared to speak to what?
I will try to answer to the best of my ability.
So my question is, do you dispute that she was disciplined beyond what is set forth in item 1 here? I mean, did you receive do you have the May 6th immediate disclosure request?
No.
Well, I can already sense that we're going to have a problem with not having the right person here, and I'm just instantly frustrated that you have no idea what's in the immediate disclosure request.
I can answer some of the questions. So back when the original request came through, we provided Ms. Harrison on Monday with a copy of her entire personnel file, including the 12 items that she requested. Any documents that we found that we can provide to Ms. Harrison on Monday was provided.
So Ms. Hairston-Omandi contends that she doesn't have written documentation of disciplinary measures taken against her.
In item 1, if she's speaking of the award that was provided to her at the time of her original hearing, I believe the accident was back in 2007. There was a decision provided to Ms. Harrison on Monday, and that award was provided, and it was in her personnel file.
Well, in item 1 of her immediate disclosure request, which I understand you don't have for some reason, she was subject to a 30-day suspension.
Correct.
Subject to her successful completion of a retraining program. She was subject to a 1-year probationary period. And beyond that, she contends that she was disciplined further. That she was subject to further discipline beyond that. So I'm trying to understand.
To the best of my knowledge, no. I cannot speak on that matter. I cannot say that Ms. Harrison on Monday was punished beyond what was required. I cannot speak to that. I'm sorry.
Would there be a written record of further discipline beyond, if further disciplinary measures were taken?
So if there was further discipline,
would that be reduced to writing?
Yes. If there was further discipline, any type of grievances that Ms. Harrison on Monday filed, we would have record of it, and
But
it
you
would be
can't
in her
speak-
personnel file.
But you can't speak to whether she was disciplined and whether that discipline was reduced to writing. Because you don't know whether she was disciplined beyond, items A, B, and C here. I'm sorry.
Beyond 2000, you're talking about from the original, isn't in 2007, correct?
Has she been subject to further discipline beyond that? Is your answer to that no?
Again, by the best of my knowledge, no, she has not been.
What do you mean by the best of your knowledge? Do you know or do you not know? I'm sorry.
I'm only answering, like I said, to the best of my abilities. To the best of my abilities, no, sir. There is no additional discipline being taken on Mrs. Harrison on Monday.
I apologize for my frustration.
Okay.
Maybe some of the other members can eke out some information.
I'm looking through the documents that SFMTA submitted in this case matter, and on page 96 there seems to be the letter that Ms. Harrison Omandi was looking for, that she said was in her personnel file that she did not receive.
Microphone.
And that it looks to be it appears to be a record indicating that the city attorney's opinion is that Ms. Harrison Omandi should not return to driving duties.
Right, and I see that letter.
That.
Thank you, City Attorney Cola.
I have a question. So the MTA has Ms. Harrison Omandi's personnel records.
Correct.
And do you have all of the personnel records?
Yes.
There are no other personnel records in the city anywhere.
Not by the best of my knowledge. All of our employees' official personnel files for our agency is within our agency. Now, there is a division file, what we call a drop file, and even that was provided to Ms. Harrison Omandi. Copies was made of that for her, and provided to her.
And also, the union would have different records for her?
I cannot speak on how the union retains their records because that's not within my realm, so I wouldn't want to answer that. I'm not sure.
Well, I understand that, but is it your understanding that the union has records for Ms. Harrison Omandi?
If there was a grievance filed, then I'm quite sure they would have some type of records, yes.
So when an employee asks for records that are pertinent to a grievance or some disciplinary action, is it the policy of the MTA to give the employee what you have, but also suggest that they go to the union to obtain other records?
Well, when a grievance is actually filed and or if an employee is being disciplined, the same records that's provided to us from the union is actually placed in their official personnel file.
Okay. I'd like to speak with Ms. Harrison Omandi, please. I guess what I'm having difficulty with is you ask for a lot of information.
Yes.
This over events over a long period of time, and this is all very important to you. I understand that, and it was just shown to us that the letter that you were seeking regarding the decision about having you drive again, we have a copy of it here, so I'm wondering, do you have a copy of it? It's
what does it say?
It's from the Safety Division Office of the Chief Safety Officer, dated February 24th, 2009.
Which one? I just got that. this is the first time I've had this, but it says that I can't drive anymore, but now that I see Mr. Nathan Ford was informed of this matter and supported my position, Mr. Daltrey's position, I need to ask to get the letter from Nathan Ford, because Nathan Ford, if he supported this, that I'm not to drive anymore, then on April 2007, he should have submitted an appeal letter the day that Mr. Paul Govachet signed off on it. He should have appealed it then. He didn't appeal it. Now, in 2009, he's agreed with James Daltrey not to let me drive. Well, this is a conflict here. Either you let me drive or you're not going to let me drive. Because if you're not going to let me drive, you should have appealed it April of 2007.
Okay. So just going back to this particular document, it's signed by Mr. James Doherty, the Chief Safety Officer. So you say you haven't, this is the first that you've seen this.
Yeah.
So I'm wondering, we have a packet of information that runs to 56 pages. So it could be that some of the information that you sought is here. And now the issue is, when was this supposedly made available to you? So now we have a timeline to consider. But one thing that may be is that the information you've been seeking is here, or at least there's enough here that will help you start filling in the pieces. And
the letter that was sent from the city attorney to this gentleman, Jim Daltrey, because he couldn't make the decision without the city attorney. Somebody had to make the decision, and it came from the city attorney, because I read the letter March of 2008 that I am not to drive. So this is, I found out. I want that letter. Okay, he sent me a letter, but where's the letter from the city attorney?
okay, so there are some documents that you had requested that aren't here.
I want that document because I read it. I seen it in the file up at the Patrol Division. The files at Patrol. And then when they found out that I read it, they were very upset. They told me I had to leave. But I've already seen it. So now this started a little, I need to find out more. I want to know, I want the letter from the city attorney who authorized James Daltrey. I also want a letter of why am I being disciplined? Why do I have to stand on a corner and write the drivers up? Why do I have to stand on the corner? Why do I have to pick up heavy boxes? Why, I want to know why I can't exercise my seniority. I have a life, I'm trying to live too. I'm barely making it 8 hours. I have seniority. I can sign on a run that pays $360-something opposed to $800. I'm missing $2,000 a month off a check. I can't pay my house note. So I'm left up pretty soon to live with somebody else, and that's not good. You like to live by yourself, Privacy. I can't, I'm not making it. Okay. And Mr. Ellison knows that. And he knows what it is he sent her, and nothing personal, but he knows he can answer the questions that you asked. He can answer the question that you asked about my disciplinary, how long I've been disciplined. I've been disciplined since 2007 to the present. I submitted the application. The arbitrator told the managers, Mike Hill, Chrissy Bora, Don Ellison, and David Hill, to assist me in finding another non-revenue position. Chrissy Bora said he couldn't help me because that's unethical. But he told me to go and apply for, traffic control. You ride the trains. I don't even qualify for that. I'm not a security guard. I'm not none of that. And even Don Ellison said, you don't even qualify for that. Thank you.
Well, it sounds like we should really have Mr. Donald.
Yes, because
Ellison
he's
here.
more
Is that correct?
knowledgeable on this.
Yes, he had a conflict, so unfortunately he could not make it.
Okay, all right, so we have that
Through
issue.
the chair, when did that conflict come up?
Just told me today.
I don't believe it.
Meeting.
What is the nature of that conflict?
I do not ask my director. He tells me to report somewhere. That's yeah. Oh, I'm sorry.
Please.
Yeah. He told me the conflict for this morning, so I'm not sure what it was about.
I am not hearing.
I'm sorry, sir.
Being said, would you ask them to speak into the microphone?
Yes,
Okay.
please. Okay.
I'm sorry. So yes, Mr. Ellison told me this morning that he had a conflict and he would not be able to attend this evening. And he only asked me to address the letter that was provided on June 3rd with regards to the employment that Ms. Omondi again was seeking, all letters and telephone calls between the union and the city attorney. We do not have records for the city attorney, at least that is not within the HR's realm. We don't have the city attorney's files. That would probably be maintained with the city attorney.
Okay, thank you. I'd like to, do members have additional questions for the parties at this time? If not, at this time, I'm sorry, I've forgotten your name from the MPA. Kathy. Okay. You'll have 3 minutes to offer some additional information in the form of a rebuttal, and then Ms. Harrison Monday will have 3 additional minutes. Do you have anything else you'd like?
I do not.
Okay.
Yes, the last time I was here, I don't remember everyone's name. This is my second time, so kind of getting used to this now. The gentleman was sitting here, the brother that was sitting here, he asked Mr. Ellison, and he asked him a question in regards to the paperwork, the information that I was asking, and Mr. Ellison kind of like trying to play dumb, and he said, okay, well, maybe I'm not asking the question right, but I have a feeling you're hiding something. And Mr. Ellison is hiding something. He's not complying with the civil service rules or nothing. The public doesn't even know that I'm sitting on the couch, that I'm on non-driving status. They don't even know. They're hiding me out on the couch. And during the time, and what we call it on the couch, sitting in the ghillie room doing nothing. And as far as the files, personnel files, as I said before, they have files on operators that no one else sees but the disciplinary managers. There's another file there. I know. There's 4 files. Personnel, human resource, union, patrol division, and other places that are hidden. And they do this when they're trying to play dodgeball. They do this all the time. They have files. And Miss Fowles wouldn't know how long I've been disciplined. She can read it, but the details of it, no. I don't think she knows. She doesn't know the detail. We need somebody who's more knowledgeable on it, and that would be Donald Ellison. He knows.
Okay.
That's why he's not here today. All of a sudden, at the last minute, he got a meeting because that man told him, when you get back here, if you don't have the information that Ms. Omondi wants, you're going to have a problem with this panel. That's why Mr. Ellison isn't here. That's my opinion.
Okay, thank you very much. Okay, the matters with the task force. Member David?
Yeah, I'd like to make a motion to find a violation of 21E, not sending a knowledgeable representative. Do I have that right, 21A? Yeah, okay, yes, that's what I would like to do.
I'll second.
Okay.
Oh, I want to be clear, I want to make the violation against Mr. Donaldson. Mr. Ellison.
Mr. Ellison.
Yes,
Okay.
just to be clear, yeah.
I'll second that.
All right. The matters with the members to discuss.
I mean, I agree with the motion, but I'm still trying to decipher, like Member Hepner, whether there's anything else we can get this complaint, and that's what's.
Well, I think, I was wondering about 6721B. I think that we're stymied because the person who can answer questions isn't here. It sounds like there is something from the city attorney, a letter that's key here that wasn't provided. So I suspect there's something that's not been provided that we could go with 67.21B. Member David?
Through the chair, sir, ask Mr. Cola. Mr. Cola. Is there anything, if we today found a violation of 6721E and then referred that to, a committee, and later we were to perhaps want to add a violation to, like a 6721B, is there anything that would preclude us from doing that in the future by only finding a violation of 21E today?
I think if you retroactively added, additional violations, there'd be some due process concerns. So I think you'd probably have to go through the channels of sending it from a subcommittee back here and then adding them in.
Okay. I'm fine. I'm happy to, if the second, to add 6721B in addition to 6721A for the sake of expediency.
Member Fisher?
Yeah, I'll second that.
Okay.
Change.
All right, that makes sense. Any discussion of that? Member Hepner?
Yeah, I think I agree with the motion generally. I'm curious as to why it's just against Ellison and not against the MTA. I don't know if we're assuming that Ellison is the custodian of records or the person who would be obligated to provide the records. I'm not sure.
I think my point, what I was thinking is I didn't want it to be Kathy. So if we need to add the MTA, I'm fine to that. That was my point, is that I didn't want it to be the person who was here tonight to be found in violation. So if people feel it's necessary to add the MTA, I'm happy to do that. I don't have an opinion one way or the other.
Well, I think we could name Donald Ellison of the MTA. It kind of covers it all.
I'm willing to amend my motion to say be Donald Ellison of the MTA.
Yeah, I'm good with that.
Okay.
Second.
I'll only add, and this is something that City Attorney Cola has raised before, is that Ellison is not a respondent to this complaint, and that does raise due process concerns if we're finding.
Actually, he is.
Oh, he is. Excuse me. I'm sorry.
He's the original complaint specifically names Donald Ellison, and he was the one who was supposed to come tonight.
Sure.
And didn't come. Yes, Member Fisher.
And the reason I second this is Miss Harrison. Oh, I can't remember your last name. Thank you, Monday. This is her second time here. She was pretty persuasive the first time. We gave a little bit of instruction. It was your first time here. You've done your homework. You've come back. You've made the presentation. And I'm sorry, Kathy, I don't know your last name, presented very well. But the answers we kept getting were, to the best of my knowledge, and I don't know. So let's get the guy in here who does know the answers, and let's sort it out. That's just, where I am.
All right. I'd like to hear public comment on the motion before us.
Peter Warfield. My apologies for not having heard much of this, but I did have some observations, and I'm not a party to this either. The first is that there seems to be a problem with any naming of anything less than a department head, because ultimately, certainly at the Ethics Commission, they don't seem to think that they can take up anything that is less than a department head, anything less than a complaint against the department head. It seems to me that when you have a complaint against a department, what you're really talking about is the head of the department, who is really ultimately responsible for what happens. We've certainly had these problems with, for example, library and library commission issues, and it has pretty much boiled down to Luis Herrera, the city librarian, being the responsible party. Whether the agent was the library commission secretary or some other subordinate, that's where the buck stops. So I'm concerned not with naming somebody in particular, but with not naming the agency head.
There was another troubling thing in the file which caught my attention immediately, and I don't know if you've discussed this, but on page P95, and it's repeated on a later page, they give as a reason for not providing something documents that they have given them previously. And I don't believe there's anything in the law that supports that. A person may wittingly or unwittingly ask for something again. They may, who knows, forgotten it, lost it, given it away. They may not realize that another request has some overlap or even a one-to-one relationship. So on page P95, the MTA letter to Mr. Young says in the third paragraph, finally, to the extent that her May 7th request sought the same records that the SF-MTA previously had provided to her, the agency declined to provide the same records again. I think that's very, very wrong, and I hope that you don't let that pass as any kind of a justification for a denial. That's not supported in the law, and certainly I hope that that was considered in your deliberation. Thank you.
Thank you.
Patrick Manetsaw. So I didn't hear the exact wording of the motion, but I've been briefed on a portion of it. I'm bringing to your attention that Member Pilpel in front of the Ethics Commission on July 28th opined that he's not sure naming a department is proper in an order of determination. All you have to do is listen to the transcript of that Ethics Commission hearing. His opinion, wrong as usual, is that only individuals can be named, not departments. So my recommendation to you going forward is that at the order of determination stage where you're at now, in considering this motion, explicitly name the proper individual in the department, and if it is unknown, to somehow address it in the actual motion, because we know that the Ethics Commission will listen very closely to the motions made and consider the entire record, and they will take a microscope to the order of determination and your motion, and then if it gets to the stage that it goes to CAC or EOT and then comes back here and then finally has a referral for enforcement to ethics, it's got to be naming names of who you're finding responsible. And to that extent, because Commissioner Keene rightfully arrived at the conclusion on July 28th that department heads are in fact responsible for the conduct of their employees, regardless of the size of the department, because Mr. Pilpel was quibbling over whether small, medium, or large departments are held to different standards about whether the department head knows of specific sunshine complaints filed against them. So you really need to amend your processes to explicitly state in the motion, in the order of determination, if it gets to the referral for enforcement to ethics stage, you got to name names. You got to include the department head as being responsible in all cases, whether he was named on the initial complaint or not. Because I suggested to the Ethics Commission in rebuttal to Mr. Pilpel that it is within your jurisdiction to add department head names at the point that you're issuing referrals for enforcement. You need to take that discretion at this stage as well. Thank you.
there any additional public comment on the motion?
Oh, and this motion should be amended to include names.
Okay.
Madam Chair.
Member Oka.
At the time that these issues happened to Ms. Omandi, the head of the agency was Nathaniel P. Ford Sr. Now the head of the MTA is Ed Riskin. And so if the department head is ultimately responsible for its employees, which he is, we should now name Mr. Riskin as the respondent.
Here, here.
Other members?
That is my opinion.
Okay, my thoughts on this, and I'm still running it through my mind, is what's different about this is the 60s, this 21E, 67.21E issue, that we don't have a lot of information here. So I'm not sure where this is ultimately going. It would be nice if at compliance and amendments where this will be sent if it passes, if Ms. Omandi will receive everything she's asked for. So those are just my thoughts off the top of my head. Anybody else have thoughts off the top of their head?
I mean, I personally think that by naming this FMTA as part of the, as, you know, the respondent, or I'm sorry, finding them in violation, that we leave open the door to later name Ed Riskin if that is what we need to do. But that was the point of adding SFMTA to, I think, the complaint.
Yeah.
Yeah. I mean, so I think we're a little bit putting the cart before. I mean, we're talking about sending this ultimately to ethics when we're just at a 21E, like we're trying to find out what we don't know. So I think that before we go to ethics, it would come back to the full task force, and if at that time it was necessary to specifically name Ed Riskin, I think we could do it at that time.
Okay, I'm thinking the same way, actually. So, anybody else? Member Hebner?
Well, my only question is for City Attorney Cola, just if you could clarify one more time, what issues we might bump up against naming somebody who's not listed as a respondent in the complaint.
I mean, I think it leaves you open. It leaves you vulnerable to someone coming back, a potential respondent that's added later, saying, "I never had a chance to defend myself at this initial hearing." But there's nothing we could do about that now. This complaint, was drawn up as such, and it named the respondents that it named. We're already at this phase. How ethics responds to that, if someone is added later, I really can't say, but there's always a due process concern.
And your opinion as to whether we're cut off from, well, it's the shape of I understand the shape of the complaint sort of dictates who we can find an allegation against or who we can find a violation against at this point, it seems. Is that, but you're saying that the respondents that are already named, I believe are the ones that there won't be any due process concerns at all. I don't know how ethics will respond to a later respondent being added in down the line. Right. But by naming the MTA generally, that leaves the door open to, the responsible party being held accountable, the responsible party within the MTA being held accountable at that point.
I suppose. Unless they just hold them responsible as a whole, and in which case there's no individual that may be facing any ramifications here,
except for Mr. Ellison, of course.
Yes.
I have a question about this. So, right now we're naming Mr. Ellison. We have named the agency, and this will go to compliance and amendments. And at that point, we'll presumably learn more. We might even settle the whole thing. But if we find out that it looks like information is being withheld, and we refer it back to the task force. At that point, could we name Mr. Ruskin, and he would have notice that it was going to come back here?
Sure. It would be a clean slate. They would have a hearing, from the initial phase. You could rename whoever you'd like at that point, and there'd be no due process concerns there as long as they're given notice.
Sure. Okay. I think that's kind of what we were thinking, but we hadn't talked it out. All right. Okay. At this point, I'd like
I just wanted to comment on that from my perspective. There are many times where the department heads assign a custodian of records, and in addition to that, I cannot send an email directly to a department head. Their email addresses just will not accept any emails from me.
Really?
Their email addresses just do not show up on the email server, and so and they get bounced back to me. So I work with the custodian of records with the departments as their assigned representative. So I don't know, that's probably an issue we should probably discuss at the Rules Committee.
I would think so, yes. Okay. Take a note.
Yes, it's always my assumption that if I send it to the custodian of records, that they are informing the department head.
So you look at them as the proxy to the department head since?
Yes.
Okay.
And if we can write that down and make it policy, that would be helpful.
Okay. So the clerk of the board may help us with this too.
Yes.
Good. Okay. All right. Rules Committee, you have number one thing. Okay. At this time, Mr. Young, would you call the roll on this motion?
On the motion to fine Donald Ellison and the San Francisco Municipal Transportation in violation of Sunshine Ordinance Section 67.21E and 67.21B. On that motion, Member Rummold?
Yeah.
Rummold, aye.
No, I'm sorry.
You want to pass?
Yeah, pass. I didn't know we were voting on the B part. I thought it was just E.
Member Winston?
Aye.
Winston, aye. Member Wolf?
Aye.
Wolf, aye. Member Hepner?
Aye.
Hepner, aye. Member David?
Aye.
David, aye. Member Fisher?
Aye.
Fisher, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Hyland?
Aye.
Hyland, aye. Chair Washburn?
Aye.
Washburn, aye. Member Rummold?
No.
Rummold, no. The motion passes.
So this will go to compliance and amendments.
May I ask if there are any specific instructions besides the referral?
Yes, that Mr. Ellison appear at compliance and amendments,
Yes.
and that he reviews Ms. Amonde's request and provide any outstanding records if something she's asked for cannot be provided, then to give some reason why the information is being withheld. So, an accounting of what's been given and what's they don't have or they're withholding.
Thank you.
Thank you. At this time, let's adjourn for
Recess.
Recess, sorry. Recess for 15 minutes. It isn't even that late.
I know, it just feels...
Meeting is called back to order at 7:30 after our recess, not our adjournment. Okay, so Mr. Young, would you call the next item on the agenda?
Item number 10, file number 14065, Civil Grand Jury Report, Ethics in the City, Promise, Practice, or Pretense.
Yes, you're up. All right. We have some competition out there. I'm not sure what's going on, but... Oh, okay.
Mass Mutual, the insurance company, they're having an event, and they've got a band that's doing all 60s stuff.
Okay.
Okay. Cool.
With a limited vocal range, I was out there.
Okay. All right. So last time we began discussing the items that we're to respond to in order. We discussed the first two in particular. I took some limited notes. We have the recording. I'd like to start tonight with, let me get on the right page here. So we discussed number 11 and number 12. And we're charged specifically with commenting on the findings, whether we agree or not, or we have things to add. And then also to respond to the civil grand jury's recommendations. There are a number of ways we can do that. We can agree or disagree or make suggestions. So I'd like tonight, we actually have 4 that I'd like to go through, the remaining ones. And then this is my idea for how to proceed after that. Well, what I said last time was I hope that we could work through consensus and so that it would be the sense of our body as to what we believe the issues are, the nature of the issues, and how we should address them. And then after tonight, I thought that with Mr. Young's help and note-taking and our note-taking, that perhaps Vice Chair Hyland and I can work on crafting our responses. We would then circulate this as part of the agenda for next time, the meeting at the end of the month.
That would be on the 26th, and this item is due to the response is due to be sent out to the judge on the 26th also. So I don't believe the timing will work.
Okay. I was under the impression from something I saw that, is that the case? Do we really, the 26th is the drop dead date? Because I thought that the responses went to the Board of Supervisors and they weren't taking the matter up until September. I mean, I had been thinking the 26th too, and thinking tonight was the last night, but we didn't get very far last time. Could the member of the civil grand jury, somebody let us know what our strict deadlines are and when we have to do what? By when?
Elena Schmidt. I wish I could give you a really strong answer. This is the deadline. What we do know is 60 days from the time that the report comes out. However, I also understand what you just said, Chair, which is that the responses go to the Board of Supervisors, and the supervisor holds the meetings, the GAO does, the Committee of the Supervisors, and we do not know when that meeting is going to be. And I don't know who enforces the 60-day, 90-day rules. So that's as much as I can say. I know it's supposed to be 60 days. I don't know what that means if you don't meet it.
Okay, so our response is to go to Judge Lee.
That's correct.
Okay.
Go ahead.
Mr. Ravensby, could you have something to add?
This is something that's ambiguous in the statute. Basically, if we address something to an agency head, the agency head has 60 days. The statute says no later than 90 days, the governing body of the public agency shall comment to the presiding judge. And you guys are kind of not exactly a governing body, but you're not an agency head either. So I mean, if you're a few days late, I wouldn't worry about it too much. I mean, it sounds like you're going to be pretty close to the date.
Right.
Yeah.
I just want to make sure that we have ample time to deliberate, and then that our draft is reviewed and vetted, and then we can send it on. And
Right.
so after. So
And the Board of Supervisors never acts within the 90 days on the stuff they're supposed to respond to. But, it's just, there's sort of a process where, we put it out at the end of June, people act on it during the summer. In the course of September, a subcommittee of the Board of Supervisors takes it up, but they usually just take up a couple at a time, and they only meet twice a month, so sometimes that goes into October, and then they come up with a resolution that goes to the full board. So and that's just sort of how it gets done in San Francisco.
All right. Yeah, we are really laid back here, and we discuss things forever. So, all right. I think the game plan I outlined, that tonight we'll talk about the remaining 4. We're going through them, deliberatively. I hope that we'll have some consensus at the end of the evening, and we'll put together a document. You'll all see it in time for members of the public, everybody, before the next meeting of the full task force, at which time I hope everybody will be reasonably happy with it, and then we can get it out shortly thereafter with some changes, I'm sure. Okay. So moving in order, the next recommendation, we could take them, I think we could take them together because they're 17A and B, they're related. So this is a recommendation regarding the official calendars.
Number?
So 17A and 17B, and these are discussed on page 20 of the report.
Recommendation 17A, reading from my, just the recommendation itself, the Ethics Commission staff should collect the official calendars prepared under the Sunshine Ordinance monthly, convert them to electronic form, and post them online. Recommendation 17B, the city attorney and the Ethics Commission ensures that those officials subject to the calendaring requirement and their administrative staff be trained on the law's requirements.
Okay, at this time, does anyone from the civil grand jury want to speak to this? We may have questions for you, but...
It's Janice.
Hi.
Hi.
I'm Larry Bush. I was a member of the grand jury and a member of the committee that worked on this report. What we learned as we went through the calendars was that even though all of the city department heads and other officials have to sign that they've had ethics training, when we looked at the ethics training, there was nothing in the training that dealt with calendars. And when we looked at the city attorney's guide to good government, which has a number of issues dealing with open records, there was nothing on calendars. The third thing that happened was that when we asked various departments for a specified month to give us their calendars, the calendars that we saw did not comply with what the Sunshine Ordinance required. What it requires is that you say who the meeting is with, what the topic was, and what we saw was that sometimes who the meeting was with, but not what business they had with the city or what the issues were that they were discussing. And on the final piece was that we had responses back from the Board of Supervisors. Most of them responded with some kind of calendar, but there was a supervisor who pointed out that the Sunshine Ordinance does not include supervisors among those who are required to maintain a calendar and make it disclosed to the public. And so We asked the city attorney to review that, and the city attorney concluded that that was accurate, that the board is not covered. So our recommendation was that the board also be covered, and also that everybody be trained in what exactly is supposed to be in the calendar.
Okay, thank you.
It was
We
pretty
may-
straightforward.
Right, okay, thank you. So we have the first recommendation is that you've heard them, that the ethics, it looks like it's with the Ethics Commission to collect them, convert them to electronic form and post them online. And then it's a matter of who should ensure that the officials subject to this requirement be trained. So, members, do you have comments, thoughts on these? Member Wolf.
Are we talking about 17A task force response right now?
Yes.
Okay.
Well, 17A and B. Yeah.
I mean, I think that what's outlined in the task force response makes sense, but I'm curious why it's our place to say that it would inappropriately shift responsibility from department heads to the Ethics Commission. Like, it feels like that's outside of our scope as a body to decide how the department heads versus the Ethics Commission should deal with the calendars. I think that it does make sense. It does seem strange to have the Ethics Commission have the responsibility to post the calendars, and perhaps it would make more sense to have them have the responsibility to ensure that the calendars are posted. But I just still have some reservations about us taking on that role as a task force of telling the department heads and the Ethics Commissions how to divvy up that work.
Member Hepner.
Yeah, if I could respond. The concern may be lessened if we just take out the word inappropriately and leave it as the task force believes that this recommendation would shift responsibility from department heads to the Ethics Commission. It makes it a little bit less of a normative response and something a little bit more descriptive, because I think that is what it does. And we don't have to make a judgment as to whether that's right or wrong. I personally think that it should be incumbent on the department heads to post their own records and put them in a format. You know, it just seems that should be the job of the department head or whoever is designated in the department to perform that function. But I understand if there's reticence to tell them what they're doing right or wrong, that I totally understand and sympathetic to.
You mean you think it's inappropriate for the task force to?
I think Lee's suggestion is a sound one. I'm not sure that it wouldn't also make sense to get rid of that first sentence and then just leave it as it is with getting rid of the first sentence and inappropriately, and then it becomes no longer a prescriptive sentence.
I'm sorry, I'm not seeing the word
What page?
Yeah, where are you? I'm confused.
On the task force response to recommendation 17A will not be implemented because it is now reasonable. I'm suggesting that sentence should be stripped, should be removed. And then the next sentence is the task force believes that this recommendation would inappropriately shift responsibility from department heads to the Ethics Commission. And Lee had suggested that we potentially scrap the word inappropriately, at which point it no longer becomes prescriptive.
I think you're reading from, if I'm not mistaken, are you reading from David Pilpel's?
I'm reading from the document that was handed to me 10 minutes ago.
If I can just clarify, I just had Victor Young pass around something that I prepared in advance of this meeting, which is effectively a compilation of what Member Pilpel put together and what Chair Washburn and myself put together, both of which documents were presented in the last agenda. I just, quickly smushed them together to make a more collaborative response from Member Pilpel's recommendation and the recommendations that Chair Washburn and myself made. So that's what you're reading from and what Member Wolf is referring to. These are totally revisable and completely open to discussion. This was just my independent effort to update the task force on what the status of our discussions had been thus far.
Made public. Excuse me.
I submitted, I submitted this document to Victor Young yesterday for distribution to the task force. I knowing full well that it was too late to get into the full agenda packet. It was not distributed to any member of the task force before this meeting. I printed out enough copies, I thought, to distribute to members of the public and members of the task force. And this is the first time that anybody is seeing it. So,
excuse me, yes, you're bad. All right, thanks for the clarification. I was completely lost, and
I'm sorry about that.
Okay, we're having some process issues here. All right, so this document is simply a mushing together. It's a mashup of what's already been out there.
A compilation, a copulation, a conflation. Any of those words would work.
Okay, so it's meant to be something for us to work from.
And it's by no means a consensus or anything that should be voted on right now.
Madam Chair,
Vice Chair Hyland.
Could I recommend maybe that we share and we collect 4 or 5 copies and give it to the members of the public?
Yeah, who does? Yeah, let's.
Take mine.
One.
Oh, okay.
My apologies for the procedural indiscretion.
Through the chair, I was
Member Wolf.
I was on page 3 of this document.
Okay, now, all right, I just read through now. Okay. Mr. Bush, do you?
May I offer a clarification about why we suggested it go to the Ethics Commission?
Yes, if you would, please.
Is that if it's independent in each department, you won't always see how things are tracking from one department to another. So let's say you're looking at something at the planning department, and also building inspection, and maybe it's the Board of Permit Appeals. And all 3 of them are taking up the same issue, meeting with the same people. But you would have to go from one department site to another department site to a third department site. And for the benefit of the public and access of the information, it seemed logical that all of that information be in one place, just as they do all of the Form 700 disclosures, regardless of which department it is in one place on the ethics page. So that was the reasoning for it.
Oh, I'm wondering, though, it seems that this kind of information is really regarding a public records, and wouldn't our body have more of a direct role, or wouldn't it fall more in our purview as something to help set the guidelines for how this information should be captured in the first place, and then how it should be made available and displayed to the public? That's sort of has been historically our area of expertise.
We would consider that a raison d'etre.
Pardon me?
We consider that the raison d'etre for your existence.
Right, exactly. So I'm just thinking the Ethics Commission, to be very pragmatic, I'm wondering whether they would have the staff, I mean, they have way more staff than we do, but whether they would think that they could possibly do this.
I think the point is just that someone should do it who's responsible for records.
Somebody, okay. Member Rummold.
I don't see any harm necessarily in suggesting that ethics should do it on top of already, on top of there already being a requirement that other agencies themselves do it, to have ethics collected in one place doesn't strike me as a problem. And another suggestion along those lines to the actual text would be to take out instead and just say, this is what we're going to do.
Yeah.
Excuse me. So instead is, you're reading the task force response. We're still looking at,
Yes.
okay, Member Hepner's.
So as I understand all the edits, the paragraph would actually read, the task force believes that this recommendation would shift responsibility from department heads to the Ethics Commission. The task force, through its Compliance and Amendments Committee and/or its education, intend to in the next 6 months.
Chair Washburn, can I ask one of the members a question?
Yes, so please, yes.
People out there, Mr. Bush, don't get up. Don't get up. Are you still on the civil grand jury? And like, how long do your terms go? And
It ended on June 30th, but we are bound by the confidentiality for a lifetime. And in the interest of discretion, we don't discuss beyond what's in the report itself, and particularly not until after the board and each department has had a chance to respond. In which case,
your term has ended, though. You're a free agent now, in essence,
well, I'm
but
free
bound
except
by,
for having taken an oath of office,
Right.
facing a misdemeanor prosecution.
except for that pesky
That's
little
a
thing.
small
But,
thing.
oh, okay. I was just wondering if you and your colleagues are still. Are you any of you still on? You're all done. Mazel tov. Okay. Well, thank you for your
Mazel tov.
service. I got approached once, to be honest. I was like, no way. So thank you for doing that. You're doing God's work, as I call it.
We want to see it all the way through, the ethics especially.
Right. Members, other thoughts? So what I'm hearing from the members is that we believe that the department head should bear the responsibility of making this information available on their websites. So we don't see that important that it be deposited at a particular central place.
Through the chair, if I may.
Yes.
I understand the grand juries, Mr. Bush's idea to have them in one central space for purposes of more easily monitoring compliance. I think that that's a relevant concern that I hadn't considered. I think that, we have two options, right? Either, we put the onus on department heads to do so, and that increases our sort of obligation to monitor them, which I think should be our obligation if that's the way it's going to be, or we have them collected centrally and have, either the Ethics Commission or the Sunshine Ordinance Task Force, whichever body is going to be centrally collecting these things, that be the monitoring mechanism for compliance with the Sunshine Ordinance. So, either it's the same way of accomplishing it. At the end of the day, what is going to be the most effective way of doing it? Having the Ethics Commission collected centrally, having the Sunshine Task Force collected centrally, or keeping the onus on department heads and engaging in sort of spot monitoring of compliance of department heads. I see the validity of all three options, and I'm not sure we should take the central collection of the calendars off the table. Does that make sense?
Well, yeah, I see that having them in a central location would permit members of the public to look at the interconnectedness of the different agencies and who's talking to whom and what's really going on, which would be much more difficult if the calendars were kept in separate locations, and more importantly, we're collecting different information. I think the thing that I see as so key is what information is collected, captured, how is it, first we need to get the data, then we need to display it in a way that's comprehensible to members of the public. And then we need to make sure that that information is in a place where it can be looked at readily. So that's kind of, but who's to be responsible for each part of that is what I'm wondering about. Member David?
Yeah, I mean, I think before we talked about, at the last time, I think I asked the question to Mr. Bush, and he brought up the example of the way you can go to the ethics website and pull up like filings of like donations to elected officials and things like that. And so it would be the same type of idea. I like that idea. I just don't, I guess the thing that I'm concerned about is that I don't want to kind of let the perfect be the enemy of the good, that like if the funding is not there for the central locating of calendars, that we don't then let department heads and board of supervisors off the hook and go, well, there's not a central place to do it, so we don't have to do it. So like ideally it would be great if there was a website you go to and you could pull down, do a pull down menu and say, I want this person's calendar. Short of that, we should still also recommend, if that is not possible, that department heads and member public officials make their calendars public. And so I just don't, I'm concerned that if we only recommend one way to do it, and then there is not the funding to create that one way, that it creates a loophole that's an unintended loophole. Was that clear what I was?
Yeah, I think we need to be clear about what information needs, as I said, needs to be captured, displayed, and where it's deposited and how it gets deposited there. I think we need to be really pragmatic about that so that it actually happens. I think, as far as what's captured and how it's displayed, we can be hard-nosed about that because that's public information that needs to be available. But the pragmatics of the nuts and bolts of putting it where is, yeah, I agree with Member David. We need to make sure that we don't recommend something they're going to go, oh, we can't afford that, we're not going to do it. So we're not going to do anything. Mr.
May I make
Young?
a suggestion?
Yes.
What we do, I do several times, is that I link to other departments' web pages. We can state, just throwing a suggestion, that the ethics department maintain a list of all the department's web pages where the calendars are kept, so that they can go to the Ethics Commission webpage and click on the link to get to all the department's calendar web pages.
Well, that sounds easy enough.
I do that several times. I link to the planning departments when I do not have the ability to post that on my own website. So I do that many times.
Okay, so the Ethics Commission could have the links right there, and then we let everybody know that that's where you go to find out calendar information. And Member Wolf.
Could the Sunshine Task Force website do it instead of recommending that the Ethics Commission does it? Because that way we aren't recommending it, we're just taking action ourselves.
Well, if nothing comes of this official recommendation, yeah, we could do that. Or we could preemptively do it.
I'm suggesting that we preemptively do it, but
now we're getting really wild and crazy.
Through the chair. I mean, my only concern about that is realistically, like, we don't have a staff. Yeah. And so that's my only, like, sure, it'd be great to say, like, we as a task force could do that, but, who, like, from a very pragmatic point of view, who, are you saying that, like, would be one of the committee's responsibility or would be Victor's responsibility, like, just from a pragmatic point of view?
Chair?
Member Wolf?
Can I respond? It seems like it should be a static URL that takes you to the calendar. So all that would need to happen is a list of those URLs on a web page once, and then it should continue to work in permanence. Now, maybe the city doesn't have their web architecture set up that way, in which case that's a real issue, but theoretically it should only happen once.
It's, it really seems... Yes, thank you. It really seems to me, because actually the task force doesn't really have its own website. It's part of the Board of Supervisors website, and we go down to the bottom of that first page and then click on the part that says Sunshine Ordinance Task Force. We need to figure out, does the city have the resources to provide staff adequate to maintain a website that can provide all that needs to be done? Or should that be left to the departments to include on their website, so all we have to do is click a link? I really don't see that it's really all that difficult. We need funds to get somebody to do all this stuff, and that's the difficult part. Once we get that, then once we decide what belongs on the website, the rest of it, if we're all savvy enough to use our computers, the members should be able to access whatever it needs.
Okay, thank you. Are there other comments from the members? Member Hebner?
In our response, can we organize it like in order of preference? Have a pie in the sky, sort of like, here's what we want is a central open data API, something that's probably not going to be created in the coming months, down to lowest priority, which is nothing, and we just continue to monitor. But can we rank our responses that way? I don't know exactly what gets done with the responses as part of.
I don't see why not. I think we should seek to convey what we really want to see happen and decide what sort of our bottom line is and what to push for. Yeah, and then the pie in the sky stuff, too. Other comments? Why don't we open this up for public comment?
Thank you, Chair Washburn. I'm bothered by this draft, the mishmash, or whatever it was called, including Member Pilpul's recommendation will not be implemented because it is not reasonable. That sentence needs to be struck entirely. You should all be aware that the city passed the data ordinance, or whatever it's called, creating the chief data officer. And theoretically, departments were supposed to assign departmental data officers. Unfortunately, in some city departments, that's being assigned to low-level people and to public information officers rather than to IT staff who might be more knowledgeable. Theoretically, the city's new open data portal, Data SF, is supposed to be the new warehouse for city documents. So I respectfully suggest that that Member Hepner take another stab at this and not create a pecking order wish list, but to make an active recommendation of what you would really like to see by stipulating that instead of it going on the ethics website, or as Member Wolf suggested, possibly on the Sunshine Ordinance Task Force website, which is separate. If you go to sfgov.org, agencies, the alphabetic listing, you go down to S, you click on Sunshine and you're right there. Somehow it's somewhat separate. Instead of that, I recommend that you make the recommendation to require these respondents, as it were, to post them to datasf.org in a prominent place that deals with that sort of data, and that as part of your specific recommendation, they should have some kind of data wonk hackathon in which they develop an app to get those things updated on a daily basis so that it's on a rolling 3-day before the calendar date thing. So it's constantly updated with all full automation and no human intervention. But beyond that, I think you should state that you want this training added to the Good Government Guide, even though Ethics Commissioner Keene has indicated that the Good Government Guide carries absolutely no force of law. But you need to make it clear to them that you want to be included in the training and to have that training standardized. Finally, you guys should be considering expanding it to not only the plaintiffs named here, department heads, board of supervisors, if you're going to add that as a recommendation, but all city employees, to the extent that all city employees are custodian of records. And since any calendars maintained by mid-level or lower members are public records, eventually this should be expanded to automatically post all city calendars for all city employees on a rolling, updated basis. That would be the ideal situation. Thank you.
Thank you.
Yes. Good evening, Peter Warfield. First of all, thank you for making these copies available. I only wish they were available at the beginning of the meeting. I appreciate that the task force response specifically refers to the Sunshine Ordinance section relating to calendars. And at the risk of picking nits, it wasn't at 6729.6, it's at 6729-5 on my copy. I think it should be a clear answer whether it's going to be implemented or not. And I do think that I think some folks wanted to strike the first sentence of task force response as well as inappropriately. I think one of those needs to be indicated as to why you're doing or suggesting to do what you're doing. Perhaps I guess I think that the word inappropriately, if that's what you mean, should be in. And if you agree with the recommendation, then say so. The thing is that I've got a real problem with the 3-day allowance, as well as the potential problem of finger pointing if the Ethics Commission does this. If I don't see it on the Ethics Commission website, who is to blame? Who is at fault? Did they not put it up properly? Did their tech people not put it up properly? Did the department not provide the calendar? It gets to be a mess. Potentially. 6729.5 is very straightforward. The mayor, city attorney, and every department head shall keep, or cause to be kept, a daily calendar wherein is recorded the time and place of each meeting or event attended by that official, and so on and so forth. For meetings not otherwise publicly recorded, the calendar shall include a general statement of issues discussed. Such calendars shall be public records and shall be available to any requester 3 business days subsequent to the calendar entry date. So I think there's a split there with what's required immediately and what's required in 3 days. My reading of cause to be kept a daily calendar is that I should be able to know where is a certain department head going to, what's the calendar for today. And that's important because particularly with supervisors, if they have 3 days to post it, the whole decision may already have been made and voted on by the time I see who they've been talking to, and then it comes to the Board of Supervisors. So I'm concerned that this 3-day thing is applying in this response to everybody when 6729-5 only seems to give a 3-day time for non-key players, which are listed at the top.
Thank you.
Thanks.
Is there additional public comment?
Thomas Piccirillo. I want to thank Member David for his copy of this proposal, and thank Member Hepner for his input. But in terms of process, if you're really seeking cogent, intelligent public comment, you need to give the public the documents prior to the time of the discussion. You're making this more complicated than it is in the sense that the grand jury is making recommendations, specific recommendations. So you either agree, disagree, or partially disagree. But the recommendation regarding the calendars was that the Ethics Commission do the monitoring. Conceivably, you've already admitted you don't have the staff to do the monitoring, right? So then presumably you would agree with the recommendation that the Ethics Commission do the monitoring. If you disagree that they shouldn't, then explain why they shouldn't. But this 17A makes the recommendation to the Ethics Commission. So why have a 30-minute discussion on a recommendation that doesn't involve the task force? Finally, your response to recommendation 12, you say you're going to monitor department heads' websites. Presumably that would include their calendars, would it not? So you have the mechanism to monitor department heads' calendars if you adhere to what you're telling the grand jury and the Board of Supervisors you're going to do on recommendation number 12. Thank you.
Thank you. Any additional public comment? Okay. So the matter's back with us, and where are we? With regard to 17A, we want to strike the first. We have actually. That choice is one of the 4 that's listed here that we can choose from in the letter. This was in a prior packet, but this is a template for us to fill out when we respond to Judge Lee. And so we can agree or disagree with findings. We can, as far as the recommendations, we can say it's already been implemented. The recommendation has not been implemented, but will be in the future. And then the recommendation requires further analysis with an explanation of the scope of that analysis and a time frame for discussion. The recommendation will not be implemented because it's not warranted or reasonable. So I don't know if we're limited to those 4. Mr. Ravenswhite, could you help us out here?
Sure. What I've seen in a number of instances with departments that are called to respond to a recommendation, but they're not called to implement that recommendation, they basically say, well, we're not being called on to implement this recommendation. The city attorney gets called on to opine on a lot of things, and they'll kind of say, well, it's not really our business. But you want to kind of, from the grand jury's point of view, we know there's a lot of substantive players in these areas, and while we may call on one agency to implement it, And we want to raise the awareness of other agencies, and we want them to kind of weigh in on the overall wisdom of what's being discussed. But clearly, we're not calling on you to implement it because you don't have staff.
Right.
And as one of the other speakers pointed out, Data SF is starting to centralize a lot of this information. And at this point, their largest provider of data is coming from the Ethics Commission. A lot of the places where you click on the Ethics Commission site will take you to the Data SF site.
Okay.
So it's kind of a moving world out there on how this data is being managed.
Okay, so the Ethics Commission has experience doing this already.
We'll see.
Okay. All right. So my sense is that we want to strike will not be implemented. We think that this should be done, this posting of calendars, that it's up to the department heads to do this. We think that we should have input into what data should be there so that there's compliance with the Sunshine Ordinance. That's our area of expertise, so we can make recommendations about that. And about what should be captured, how it should be displayed. And we could suggest that a way to implement it, the pragmatics of it. So would we say that the recommendation requires some further analysis, meaning we need to craft our recommendations for the data to be collected and so forth? How's that sound, everyone? Okay. All right. So we'll put together something like that. I might pull Member Hepner in on this too. Okay. All right. So 17B is a little more straightforward. We've sort of talked about it. So, members?
Sure.
Yes, Member Wolf.
I'm happy with agree.
We agree with the findings, and we support the recommendation. Do you want to add anything like that this task force, this is something we talk about from time to time, and we haven't done it really, to have more input into the annual training. We all have to take it every year, and every time I do, I see things that were left out or things that should have been emphasized. And I think that, and we haven't had the bandwidth to do this, but ideally it would be something that we would proactively do year after year. But I think for this particular recommendation, since we're suggesting we're the experts on what the information should be collected and so forth. So I would think we would be the people that would have input into the training. Say the department heads need to know this about the ordinance, and to comply with the ordinance, these are some things you have to do. So how does that sound?
That was good.
Vice Chair Hyland.
I also wanted to add, based on Mr. Bush's information, I'd like to include Board of Supervisors in here. Not that we can enforce it, but just to, get it in writing as a recommendation that they consider including their calendars as well. Whether they will or not is up to them, because I think they're exempt from that right now. But it wouldn't hurt to at least acknowledge it and get it in writing.
Through the chair.
Member Hepner.
I think that's actually the subject of finding 18 and recommendation 18. Just to
So it is. Apologies.
All right, we were not asked to opine on 18. Member Pilpel did. I mean, it's a logical thing. But as part of our response to 17B, we could say that and even to 17A, that we mean to include the Board of Supervisors. We strongly recommend that they start doing this, and that would be when we get around to amending the ordinance. That's certainly something that needs to be put in there.
I'm sorry. Yeah, through the chair, I would even encourage us to add language that, like, saying that keeping with the best practices of open government, we strongly recommend that the Board of Supervisors do that.
At this time, is there public comment on 17B?
I will stick.
Oh, pardon? I just think it makes. No, I see what you're saying, but Okay, we're discussing about when to take public comment, and in my mind, it makes sense to take it after each recommendation. So we can hear what they're saying. It might change what we're recommending rather than wait till the very end.
And then we're going to get out of here at 10 o'clock.
It's 8:20, and I think we can. I would ask everybody to
Be brief.
Be brief and be very pertinent.
Okay, so to be brief, I am troubled by the new draft on 11 and 12, which I will email. Wait a minute. I will email my concerns to them, to Mr. Young, with the proviso that he email it to each task force member before you consider the next draft. As to 17B, I strongly recommend that you take the very last sentence of your task force response and reword it more. I'm struggling with the word. Be stronger by moving should be coordinated with the task force earlier in the sentence, saying that you recommend that the task force be a joint partner in developing the training materials. And as to the rest of it, really wondering if you guys want to be saying that you're going to be reviewing each of the departments' websites or some survey instruments over the next 12 months to assess or to review and assess their compliance with the calendar requirements. It's a lot of work for you guys. I'm not sure that it needs to be in the actual response itself.
Okay, I just want to say that these are Member Pilpel's notes, and
which still strongly disturbed me.
Okay,
this should not have been based on Mr. Pilpel's recommendations at all.
We need to move on. Next member of the public.
Richard Ney. I agree with the recommendation on the Board of Supervisors calendars, but I think there's an extra step that you can take, and that is that the task force draft a letter signed by the chair, a letter to each of the supervisors asking them to introduce an amendment to the ordinance. The supervisors are empowered to amend the ordinance if it will further the ordinance and if they get I think a 2/3 vote to do it. So challenge them to do it. Challenge them to introduce and pass an amendment to the ordinance requiring that they make their calendars available. Tell them that if they don't respond to your suggestion by such and such a date, you'll go to the press with it, that they did not respond. Remember, this is an election year, a re-election year for 5 supervisors, and 2 of the supervisors are in a race for the state assembly. Hold their feet to the fire.
Thank you for that.
Peter Warfield, first of all, I don't see that recommendation. I think we're talking about 17B, and I don't see that there's any role for the Sunshine Task Force in the recommendation. So I think a simple agree is fine. If you want to go through all of the material that's in here, it seems to me somewhat advisory and hypothetical. I would only urge you either to think about or to include in your answer that perhaps you'll do some enforcement so that if there are departments that are not complying with the law, that there be some official note taken of that, at least for the record, so that there'll be a record of who's good and who's not so good, and the next time it comes up or the next time a complaint is made, there'll be a record of what you have learned as you went through your review. Thanks.
Thank you. Is there additional public comment?
Brevity and relevance should be applicable to task force members as well as members of the public. I agree with the recommendation of the task force on 17B, and since Member Nee introduced 18, I also agree with the response to recommendation 18. Thank you.
Thank you. Do the members have anything else to add to this discussion of 17B? Okay, let's move on to
Recommendation 20A.
Yeah, okay.
20A, the mayor's office should establish a blue ribbon committee of experts and stakeholders in open government, sunshine, and transparency, including former Sunshine Task Force members. The committee of experts should review and update the Sunshine Ordinance as necessary and should report to both entities and the Board of Supervisors recommendations that would result in the coordination and respect for the functions of each entity.
Members. Member Wolf.
On this paper that's the conjoined Pilpul and I don't know who else wrote the other part, I don't like the first paragraph, but the second paragraph seems to be fine from my perspective.
So the second paragraph states that the task force has the power and duty to propose amendments to the ordinance. And indeed, we do. It's part of the ordinance. And for the new members, I may have said this before, but we have a compliance and amendments committee, and we haven't done amendments for a long time, but we did for a while when past member Nee was chair of that committee. We, and for a number of years, went through the ordinance, chapter and verse, word by word, a very detailed set of amendments were drafted. Later on, we went through those and picked out some that we thought were most critical. And the full task force signed off on those. Then we had a change in task force members, and a lot of those recommendations went to the activists in the community, some of whom had been part of the task force in the past, this group took some amendments to the Board of Supervisors. We had several. We may have had enough to get it on the ballot, but it was very last minute. So we've done a lot of this work. And so I think that's what Member Pilpel was thinking when he drafted this. This is something certainly I've been thinking too. There were some concerns that, and Member Hepner can confirm this, there were some concerns that compliance and amendments brought up when we had our committee meeting with members of the civil grand jury that we didn't think that, we were concerned about who would really be appointing this Blue Ribbon Committee and, who they would be. And we just had a lot of those kinds of questions. And the more when I first read it, I thought, oh, this sounds like a good idea. And then I thought about it for 2 minutes and I thought, no, this is not something I'd want to support because we've done a lot of this work. It's many, many more people have been involved in this. So, Member David? No? Member Hepner?
I agree. I think in some respects we are the Blue Ribbon Committee on this, and together with the people who come here and speak with us and present things to us, we can accomplish a lot of what that suggested Blue Ribbon Committee would put forward.
Now, this Blue Ribbon Committee, it was not just about amending the Sunshine Ordinance, too. It was also, there's been another wrinkle here is, you probably figured out by now, our relationship with the Ethics Commission has been historically very bad. And just recently, they've started hearing our cases, and it was a result of them changing the regulations. They asked us to comment. We worked together and came up with regulations for them to follow that seemed to be starting to work, sort of. Maybe not as we would like, but so a piece of the puzzle here, and I think that's what prompted this recommendation, is doing something with the ordinance to ensure that our two bodies work together better, because there's a lot of ambiguities in the ordinance about enforcement in particular. But that could be part of the amendment process, and I haven't looked at the proposed. I have all the files on it, and of course we do in the office, but what we were thinking way back when, but that might need some rethinking. But Member Wolf.
My objection to the first paragraph is more structural than the content. The recommendation is for the mayor's office to establish a Blue Ribbon Committee. It's not our place to say that the mayor's office won't implement something. We have no control over what the mayor's office does. That's my issue with the way that it's constructed.
Okay. Yeah, we don't have any power over them, but we can say we don't think that's the way to go.
Right.
Okay.
Right now it says will not be implemented.
Okay, all right. So it's that's particular response. Other members? Are the other members I haven't heard from thinking along the same lines that we think the task force is the place where this work ought to be done, has been done historically? I think the pieces could be picked up from our past work and moved forward, if we made it a real priority. Member Rummold?
So I will register a little dissent here, and my concern is that we shouldn't be territorial about transparency, right? If if the mayor's office wants to take the transparency flag and run with it, why not encourage that, right? I don't know that sunshine, transparency has to issue from this body or not at all. And so I would encourage us, and that was my concern with the ethics commission thing. If the heads of each department have an independent responsibility to put these calendars up, that's great. And if ethics collects it and puts it all on their website, that's good too, as long as it supplements and isn't, the sole place for the calendars to be obtained. And so I'd say the same thing applies here. Who cares? I mean, not who cares, but I would encourage the mayor to support transparency and ethics and this task force working together.
Okay. I've registered this idea. Vice Chair Hyland.
In support of that, I would love to see former members of the SOTF drafted to help us with this. And I'm looking at one particular gentleman in the back row there. But why not have this body convened, and they could come and appear before us, and we can discuss their findings and fine tune or add our 2 cents. I mean, we have so much on our plate. I agree with Member Rimmold. Any help would be. I don't think we should discourage it.
So you're talking about a process for amending the ordinance?
No, I was talking about the blue ribbon body.
Okay. So you're saying that you don't oppose having a blue ribbon body?
I don't oppose it, no.
And some people do oppose the blue ribbon or see it as a less desirable way to go. If we're looking at amending the ordinance, I'm talking about.
I would, if I'm among the people who voiced a negative opinion, it's fair to say that I think it's unnecessary, perhaps. But that's unnecessary is different than categorically opposing it. I just don't think it's necessary.
Because of this other way of going about amending the ordinance.
Right. It's in part, we are going to be concerned with this, if we have, and that's assuming that we have to pick and choose, which maybe we don't, and maybe we wouldn't have to. So unnecessary, but maybe it would be a nice thing, I guess. Is my 2 cents.
Okay. Rommel, Member Rommel.
I mean, we can say we intend to take this up. We have that power to take this up and to review these changes to the ordinance, but more like a blue ribbon panel isn't necessarily a bad thing, right? It's in addition to, not in lieu of our own review of it.
Do we have any recommendations do we want to weigh in on what the membership of this blue ribbon committee should be? Member Wolf?
I mean, I think that no matter how we weigh in on it, the mayor, the recommendation is for the mayor to create a blue ribbon task force, and I'm pretty sure that whatever we recommend is just he's going to pick who he wants for the blue ribbon task force, and I don't think our recommendation is going to really have much resonance.
I agree with that. I don't think this is something that's appropriate for us to be commenting on. I really don't, and I think that we're chewing up a lot of time with it.
Okay. So are you saying that we shouldn't weigh in at all?
Yes.
Could I have hear from the members of the public about item number or recommendation 20A?
On 20A,
I think you should be more proactive and change the first sentence and the very last sentence right before recommendation 20B, and not say it won't be implemented, but say expressly that you disagree with the recommendation, and that you explicitly state the executive branch has nothing to do with oversight of the Sunshine Task Force. It's strictly this semi-independent, quasi-judicial body plus the power of the Board of Supervisors to adopt amendments or by ordinance. But the mayor's office has nothing to do with Sunshine, and the voters didn't want it that way. They don't want the mayor's office involved in appointing blue ribbon committees. When I asked a question of one of the ethics representatives, who I'll not name, about my concerns about why the grand jury even ventured into broaching the mayor's office, the reply I got was, make a recommendation to the task force, that they make a recommendation to have some other body create the blue ribbon task force. And I suggest it should be you, possibly in conjunction with the Board of Supervisors, but the mayor's office should be the grand jury should be told that you totally disagree with the recommendation. And as such, and in trying to keep this brief to get Member Winston and others out before 10, I strongly recommend that on the next mishmash, Member Hepner, that you draft, that you take out pretty much everything in that recommendation and get rid of it and start over. I don't think you should be telling them that you believe a ballot measure should be placed on the November 2015 ballot. And I'm not even sure that the city attorney or ethics commission should be invited into the blue ribbon committee. The voters were the ones that last amended the ordinance after the Board of Supervisors adopted it. This has got nothing to do with the city attorney or with ethics.
Right.
It's all about Sunshine. And you absolutely have to remove from this thing that city agencies, boards, commissions should be even solicited for their input on this, because they're going to lead you down the wrong path, because they don't want Sunshine.
Okay.
They want out of Sunshine.
Thank you.
Peter Warfield, I think the only blue ribbon that should be opened is Pabst Blue Ribbon. I had a similar experience to what the previous speaker mentioned with regard to the intention of the grand jury. If the grand jury didn't get it at all, I could understand and make a recommendation like this. But the very beginning of their report on page, looks like 1, in the third paragraph under issue, it says, during our 8-month investigation, a wide spectrum of local, state, campaign, political, and public sources told us. One paragraph down under summary. Well, to finish what I'm saying is everybody told them that Ethics Commission is not an effective enforcement agency. But here's the key. Summary. The jury finds that San Francisco officials at all levels have impeded actions intended to establish a culture of ethical behavior, and that the focus needed to ensure accountability and anti-corruption standards needs greater leadership from the mayor, the Board of Supervisors, the city attorney, the district attorney, and city department heads and commissions. I think that's a good summary. So why ask Al Capone to name a blue ribbon jury to review lawful behavior in Chicago? And that's what I think is doing. The mayor has been a consistent violator of the law. He has ignored the Ethics Commission letters to sack a member of the Library Commission for outrageously bad behavior. 2 years in a row, didn't even respond. So who is the mayor and to choose a so-called blue ribbon committee? And why should you endorse that? So I think the burden is on you under the Sunshine Ordinance to do your work and to make recommendations. I believe it's 67.30 that gives you broad, 67.30 that gives you broad recommendation powers. I have to say that the second paragraph at the bottom of the response for 20A, I think gives me a lot of trouble, and that is when I hear about the views of experts and stakeholders and blah, 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 and stakeholders is a hot button word for me. That usually means hand-selected to undermine the purpose. I don't see complainants, I don't see successful complainants, and above all, I don't see members of the public. So I would recommend the whole bottom half, beginning with the ultimate purpose, at least that portion getting dropped completely.
Thank you.
Thank you.
Is there additional public comment?
We're speaking on 20A, correct?
Yes.
Okay. I would partially disagree in the sense that I would prefer to see the mayor's office and the board of supervisors set up a blue ribbon panel. You know, the mayor, the irony of this grand jury report is that it came prior to the mayor's new record retention policy, so that, you know, which may violate the Sunshine Ordinance. So I'm not a fan of one branch of government doing anything. So I would prefer to see a joint mayor's office and board of supervisors put this blue ribbon panel together. Secondly, the grand jury wants to include former Sunshine Task Force members. Why only former? Why not former and present? You're the experts, presumably, and you're current. So why preclude present task force members? And finally, I do like the idea of the blue ribbon panel, though, proposing amendments to the Sunshine Task Force. I think the grand jury looked at the history of the task force and their inability to get a consensus on amendments to the Board of Supervisors. So what the grand jury, I think, is telling you is that you're not capable of doing it yourselves. So a blue ribbon panel would do the job for you, and you could then deal with your backlog of cases and discuss other policy matters. Thank you.
Thank you. All right, I fear that we're losing our ability to concentrate at this late hour, but I wanted to move on to the final recommendation and discuss this to the extent that we're able to with the concert and this late hour.
Recommendation 20A?
20B.
20B, for now, arrangements should be made jointly by the Ethics Commission and the Sunshine Ordinance Task Force to have complaints heard by an independent hearing officer who would develop a consistent legal sufficient record of the case for the decision of each body that will allow the meeting of the task force and the commission to focus on broader policy issues.
In reading over the material that Mr. Hepner provided, I don't see that it captured a couple of points that came up at the Compliance and Amendments Committee, namely that this independent hearing officer would not be the one to in our case, find violations of the ordinance or orders of determination. Rather, this hearing officer would be the one to gather or listen to the complainant and the respondent and determine what happened, and in the case of public records, what was provided and not, get a timeline, make sense of the case. We often spend a great deal of time doing that because when the cases come to us, they're sometimes pretty ill-formed. As we found that out tonight, actually. So this is an effort to have someone put together a hearing record that we can then use to adjudicate the case. So that was the big takeaway I had there, and that further that this independent hearing officer would just hear the more complex cases rather than pretty straightforward ones where we could hear them in a expeditious manner. So, Member Rummold.
I think we should be open to any and all types of reforms that would make hearing complaints operate in a more logical and expeditious way. And if this is one of them, then I think we should be open to it and consider it. And if coordinating with the Ethics Commission helps speed things up in some respects, I think we should be open to that too. Because I think right now the process itself is pretty dysfunctional, and I think we should try to fix it in any way we can.
Okay. Member Wolf.
I agree with what Member Rummel just said completely.
Some other questions that came up was at compliance and amendments was, who would appoint this person? Who, what qualifications would he or she have? And what would be the cost? I mean, there's some very basic questions like that. I can imagine a scenario where we might be pretty unhappy with a person chosen.
Right, and then also how that independent hearing officer would fit into the current scheme we have with the city attorney who prepares a record and Victor who prepares a record, and the information that we're already provided with. I think that my current thinking is more in line with what we discussed at the Compliance Amendments Committee, though, where we were more open to having this independent hearing officer, at least for the purposes of creating and maintaining and presenting precedent based on our prior opinions, so that we can be more informed with the decisions that we're making and not feel like we're making them so on the fly. And the independent hearing officer would, again, they would present not a final determination, but enough information for us to make an easy determination on a more complete record, or more thorough.
Yeah, the idea of bringing in precedent to, anything to help us think about our cases more clearly. I think you make, it often feels like we're just really in the dark and we're feeling our way, and it's hard to wrap our heads around some of these cases. So I'm hearing that there's some openness to this idea, some concerns about who would do this, but some interest in looking at it. So maybe requires further analysis and discussion, but with the understanding that we would adjudicate the cases. We would we would find violations. We would write the orders of determination. Is that sound reasonable? Okay, I'd like now to hear from members of the public.
Thank you for your indulgence tonight. Again, I have to express my sorrow that anything coming out of the EOT committee made its way into this document. I am particularly appalled about the concept of having a consent calendar. It's a wrong approach. It's not creative. Having a single task force member hear preliminary matters may be one thing, but to have a single task force member adjudicate a case, to me, seems to fly in the face of our judicial system. Typically, courts have 2 or 3 members. They never, I don't think, allow a single judge to make rulings, although I could be wrong. I'm not a lawyer, and I am not a disbarred lawyer. Specifically in the response, I think you need to strike out "will not be implemented" because it's not warranted. And I also recommend that you do not use the option of saying requires further study, because that leads to nothing. I have to disagree with Member Rummold's appraisal that the process is dysfunctional. This is about due process. How you handle voters and complainants' concerns under due process is really critical. Yeah, you need to clear up the backlog, but I'm not even sure I agree with the EOT suggestion of having an existing committee hear the complaints. I think you do need to keep the last sentence of the second, I guess it's the first paragraph, saying that the task force will seek public comment on any proposed changes to bylaws and complaints. But the independent hearing officer concept has to go. If what you need is a historical record of how you have treated similar cases in the past, that's homework for this body. It's not something that should be farmed out to a consultant or an independent hearing officer to help you develop recommendations on how to proceed on cases. In other words, this is another response that I think needs to be completely rewritten.
Thank you. Please, when I'm conducting the meeting.
Yeah, it's true. Both President Clinton and I were disbarred 20 years ago, but we still have the right to speak at public comment. I support the recommendation of the grand jury, and I agree with the comments by members Rummold and Wolf. I think that it is a recognition by the grand jury that your process is dysfunctional. And yeah, it is a power grab, but when the process is not working, then you think outside the box. So I think you ought to support the recommendation 20B. Thank you.
Thank you.
Nixon as your supporting example?
Recognize China.
Okay, we're getting punchy. That's because it's late.
Can we start my 3 minutes at the beginning, please?
Sure.
I think this is another, I think the evaluation of the civil grand jury may be in agreement with what Member Rummold and others have said about dysfunctional or dysfunctionality. but I do think you've got a very good group here. There's one idea here that maybe might help, in my opinion, and that is the complaint committee, if it were to help structure things. I certainly think that your city attorney, who unfortunately has left, and I think came in for some criticism in the report, has that role. He ought to be giving you the history of what happened in same or similar cases. When I asked him the last time that I was here about why didn't he tell you that the Arts Commission was a serial violator prior to the hearing that evening, and that they had already been told by the previous task force, I believe on a unanimous vote in a library users association, that they were required to have all their subcommittees keep minutes and audio recordings. He said that's not my job, he says. And I don't agree. I think you're supposed to have under the law and a unique city attorney who's appointed to help you, and that should be part of his job. I also believe, and I've heard the lawyers may know better, that the city attorney probably has a very extensively annotated sunshine ordinance so that the city attorney would know all the previous references to particular sections so that they would know what their previous advice was and what their previous experience was with respect to particular complaints or objections to particular aspects of the Sunshine Ordinance. So that's, I think, something for to press your city attorney for. The reason I mention compliance and amendments is I think that your procedure here is highly chaotic and that you do fly by the seat of your pants and prior task forces as well, so that somebody specifically complains about section such and such A and B and C, then there's a lengthy kind of discussion, which is worsened by jamming complaints together. But then all of a sudden somebody makes a motion, let's find a violation of A and X. And there isn't even a specific discussion of B and C, which was requested. That kind of chaos, I think, could be assisted if you would structure and say, this is what was claimed happened. If it happened, it violated these sections, and we will find violations if we find that what the complainant says is correct, plus other things that our city attorney and we deem appropriate in this instance. Thanks.
Okay. It's important that we try to be brief at this late hour. Is there any additional... Mr. Ravensway.
I'll be brief. This recommendation, we hope, could make your life a little easier, and we hope you can support it. It would really just initiate a process whereby you and the Ethics Commission might work something out. If you come out against it, I'm sure the Ethics Commission will take a hike on it as well. So I think it would be very positive if you did support it.
Thank you.
And it's not the end of the line by any stretch. You'll see how it plays out from there.
Thank you. All right, so it's now up to us to draft some responses based on our discussion tonight. And I've been taking some notes, and we have the recording. I'm going to ask Mr. Young if he could send some bulleted comments our way, or does that make sense? Is that something you can do, or?
I will do the best I can.
Oh, thank you. Thank you so much. And so then, Vice Chair Hyland, I'm going to ask Member Hebner we'll work together to come up with something that will be a part of the packet for next time. And we'll be a little bit late, but I don't think anybody's going to do anything about it. I don't think we'll be alone in that. It is August, by the way, yeah. Member David.
Just very quickly, I would like to thank you, Chair Washburn and Member Pilpel and Member Hepner for putting together these recommendations. I know it's a lot of extra work, and I just want to say how much I appreciate if Member Pilpel was here too. I'm sure he's listening somewhere, but yeah, thank you guys very much for doing the work.
Thank you.
Thank you. So, Mr. Young, would you call the next item on the agenda?
May we continue this item to the August 26th meeting of the Sunshine Ordinance Task Force?
Without objection? Okay.
What agenda item?
We're continuing. We're going to be discussing, this will be on the agenda for next time to complete our work.
Item number 11, approval of minutes from the July 22nd, 2014 meeting.
Do I hear a motion to approve the minutes?
Move to approve.
Second.
Okay, the minutes were circulated. I know I sent in a few edits. Any discussion among the members? Do I hear public comment on the motion to approve the minutes?
Yes, Peter Warfield. On items 3 and 4, I think that my comments are inadequately summarized. On item 3, I said that not only did I support what it says is this: Peter Warfield expressed support of the motion and stated that audio recording is required. This was Paula Daytesh's complaint about the Arts Commission for not posting meeting minutes, audio recordings, or both for various meeting minutes, and they came up with the same argument that they had 2 years ago when we had exactly the same complaint, and they were told by this body, you can't claim that subcommittees you've created are not subject to the minutes requirements and the recording requirements because they're not named in the charter. That was a very clear decision, and it was a precedent that had come long before this complaint. And so I think that this needs to show that what I said was that they have made the same violation, they have been found in violation previously by this same Sunshine Ordinance Task Force, and that this was a repeat or a willful violation as a result. On item 4, it says here, Peter Warfield stated that the Deputy City Attorney should provide histories of previous task force findings in relation to current complaints. I think that's pretty good. I think the concept of precedent might be included there somewhere, because that's exactly, in fact, what we've been talking about here, and certainly what I mentioned, which is your city attorney, I think, can and should do that. Thanks.
Thank you. Is there additional public comment on the minutes? Mr. Young, would you call the roll call, please?
On the motion to approve the minutes, Member Rummel.
Aye.
Rummel, aye. Member Winston.
Aye.
Winston, aye. Member Wolf.
No.
Wolf, no. Member Pilpel. Member Pilpel is not present. Member Hepner.
Aye.
Hepner, aye. Member David.
Aye.
David, aye. Member Fisher.
Aye.
Fisher, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes. Item number 12, Sunshine Ordinance Task Force Complaint Backlog, Possible Solution, and Meeting Schedule. I believe I included a copy of the meeting schedule in the packet. The Sunshine Ordinance Task Force will be meeting on the first Wednesday of the month and the fourth Tuesday of the month. The Compliance and Amendments Committee will be meeting on the third Tuesday of the month bi-monthly. I believe they will start meeting on August 19th. The members I have listed currently are Chair, Member Hepner, second member is Oka, third member is Washburn. The Education Outreach and Training Committee shall be meeting on the second Monday of the month, starting September the 8th. The members are, the chair will be Chair Hyland, The other members will be Pilpel, David, Winston, and Wolf. The Rules Committee will begin meeting on the third Tuesday of the month bi-monthly. They will start meeting on September the 16th. The chair is Member Fisher. The other members are Member Rummold and Washburn.
We can discuss this. I just wanted to say that I'm listed on two committees. The Rules Committee, I'm hoping that the New America Media person will take that over. I'm just kind of the placeholder. Here, what is the status on?
I believe the person has been confirmed by the city attorney to be qualified for the seat. There was a question as whether they qualified as a member of the media. I believe the city attorney has confirmed that they are, and it's awaiting a meeting before the Rules Committee.
So my question is, are these committees set in stone already? Is there any discussion about it? I don't remember us talking about this.
Well, what I did, I asked everybody.
I'm just going to cut to the chase. I don't think that Vice Chair Hyland should be the chair of a committee. I think each committee should be chaired by somebody who is not an officer, of this body. That's how we did it the last 2 years, and that's just my recommendation. You can do with that what you wish.
Okay, so I've heard that.
I'm certainly open to discussing that.
That said, if you get nobody to volunteer for that, then, the chips fall where they may. But I just want to know if you reached out to any of the newer members, if they wanted to chair that committee.
I guess what I was thinking was I thought that maybe the newer members would not be ready to chair, and so...
We all did it last 2 years, and we were all new.
All right, okay, I hear you.
I think the thought was also that I might be an interim until maybe one of the new members are ready.
Or another member. It was, an interim thing. And I attempted to get everybody their first choice, which I think I did, so... And given the late hour, I'm wondering if we could continue the discussion about addressing the complaints to the next meeting, if that's all right. It's outlined that and we discussed last time about having each of the subcommittees also hear complaints
I think it'd be worth, through the chair, just refreshing everyone as to what the structure really means. In other words, 1 month they'll act as a EOTC, the next month they'll act as complaints, and that way we'll get 2 to 3 complaints committees heard each month.
Right.
Is everyone on board with that? Understand what this schedule represents?
So everybody will be hearing, and we're not adjudicating complaints. We're just, as the old complaint committee did, you were determining jurisdiction. You were also trying to see if there was some way to, if it was a timely manner, do some remediation, or also just clarifying the issues and making sure all the documents were there, kind of putting together a record that made more sense. So we're trying this out, but we used to do this in the past, so we're going back there.
In essence, every subcommittee will be a complaints committee, one on, one off, one on, one off.
Mike, please, I didn't hear that. Okay.
So every subcommittee will also be a complaints committee. In other words, month 1, they'll be their subcommittee. Month 2, they'll act as a complaints committee. And month 3, they'll go back to being the original subcommittee and doing that work. So we're alternating as a subcommittee and as a complaints committee. Back to subcommittee, complaints committee. And that way we have 3 additional bodies that are starting to get through this backlog, mediate, determine jurisdiction, kind of do a lot of the groundwork as much as possible. That's what we're planning.
And this brilliant idea came to us through Mr. Young. Has wonderful, brilliant ideas.
I believe we do need to work on the schedule because I believe my limit is a meeting a week. 1 meeting per week. So we'll need to rework or take a closer look at the schedule to be sure that this is possible.
Okay. So if we could, is there any public comment on item 12? Keeping it brief and pertinent.
Peter Warfield, I've mentioned this before, but it was a long battle to get this body to meet on a different day than the Board of Supervisors. It's something that this body did do originally, and for a long time until the Board of Supervisors changed their meeting date from Monday to Tuesday. And then there was the same date, and eventually you guys decided to meet on Wednesday. So I'm very troubled by the fact that basically it looks as though half of the full task force meetings are on Tuesday and all of the subcommittee meetings, except for the education, so 2 out of 3 subcommittee meetings are on Tuesdays, which is precisely the time that the Board of Supervisors meets, and I think that's very bad. I do wish that you had listed the committee members on the agenda packet, but I hear that it's available as a separate sheet. Thanks.
Thank you. Is there additional public comment?
To be really brief, did I understand you are postponing a fuller discussion of this agenda item to another meeting? Or is this it?
No, we're going to be talking about this some more the next time.
As another agenda item at the full task force?
Yes.
Okay, good. I'll weigh you down then.
Thank you.
You mean weigh in?
No, I think you said it right the first time. Okay.
One question is concerning this month's meetings. Shall the compliance amendments start meeting on August 19th, or shall we delay their start?
Well,
they do have agenda items that they can hear.
I think we should move ahead.
I'm sorry, what was that?
The Compliance and Amendments Committee will begin their meetings with new membership on August the 19th. The other committees are not scheduled until September, and we have time to make final decisions on those.
Thank you. Could you call the next item on the agenda?
Item number 13, Administrator's Report. To be brief, we had approximately 235 calls, emails, and office visits concerning the Sunshine Ordinance Task Force. I have listed 2 pieces of communication. One is concerning the City of Minneapolis open data policy. I believe that Member Hepner provided that to the committee. I do have an email from Jamie Liu. She is writing concerning file 14020, where she is pointing out issues she had with the hearing. However, it's too late for that case to be revisited. There are 5 new complaints for the month of July. They are listed. I have attached the complaint log. The total number of complaints has gone down slightly from the previous month. We went from about 59 down to 55.
All right. Thank you. Members, do you have any comments? Any public comment on the administrator's report?
Peter Warfield, I always appreciate the information that's provided. I have some comments about it, which I won't make tonight. The administrator's report appears never to be included as an attachment. It's a great loss because if you want to do a simple thing like look at the complaint log, you got to contact the administrator, or I don't know where else to dig around for it. But I think that this is a monthly report that you get. It happens every month. I don't see why it can't be attached, period. And it never seems to be. So I think you should insist on having the administrator's report run for the month up until whenever it is that you can include it as part of the agenda. Certainly, if you don't include it in the agenda, you should include it in the minutes, since it was something you discussed that was not on the agenda. Thanks.
Thank you. Is there additional public comment? Mr. Young, would you call the next item on the agenda?
Item 14, announcements, comments, questions, and future agenda items.
Members? Member Rummold.
Sorry, I sent what I wrote in response to that one complaint we heard, and I don't know how to make that. Can we put it on the agenda, or can people? What do we do with it now that I've written it? I guess is my question.
I think it should go on the agenda for next meeting.
Okay.
Yes. Thank you for taking that on, following through. Okay. Anything else? Member Wolf.
So there was another case that I had agreed to reach out to the ACLU regarding. I don't have any new I did, and I don't have any new information that helps in terms of the adjudication. So just letting people know that I did follow up and nothing new came out of it.
Okay, thank you. Thanks for reporting in. All right, do I hear a motion to adjourn?
So moved.
Okay.
Second.
The one. Copley.
Yeah.
Copley.
Yeah.
Yeah.